Morning to one and all. I would like to thank the Honorable High Court, Madras, and the Board of Governors for giving us this opportunity. It gives me immense pleasure to welcome each and every one of you to participate in the Sensitization Programme pertaining to the provisions in Chapter 11 and 12 of the Motor Vehicles Amended Act 2022, as directed by the Honorable Supreme Court in Gohar Mohammed vs. State of UP Road Transport Corporation and others. I heartily welcome all the honorable lordships of the Madras High Court, all the principal district judges, additional district judges, special judges, secretaries of the district legal service authorities, chairman of the Permanent Lok Adalat, nodal officers and panel lawyers of all the insurance companies, the superintendent of police, and police officials, and the regional transport officers and other transport officials of the state of Tamil Nadu and Puducherry to interpret the amended provisions of Motor Vehicles Act and Rules 2022. We have with us an eminent resource person, Mr. S. Srinivas Raghavan, Advocate, Madurai Bench of Madras High Court. Mr. S. Srinivas Raghavan enrolled in the year 1989 and he has been practicing for nearly 34 years before the various legal forums. He is specialized in Motor Vehicle Act, Workmen's Compensation Act, Consumer Protection Act, and other civil laws. He is very much appreciated for his extensive PowerPoint presentation and for his expertly written articles published in various law journals. There is a saying that judges don't age, but time decorates them with more and more wisdom. Likewise, we wish that this session would enhance and expand our knowledge regarding the amendments made in the Motor Vehicles Act and for implementation of the directions issued by the Honorable Supreme Court in Goham Mohammed case. I wish you all a happy learning and request one and all to discuss, deliberate, interact, and make use of the resource person to your best and clarify all your doubts. I wish everyone a productive weekend. Now I invite Mr. S. Srinivasan Raghavan, advocate, to handle this session. Welcome, sir. Thank you.
Yes, sir. Very good morning, each and every. Am I audible, sir? It's clear now?
Yes.
A very pleasant morning to one and all. It's a privilege to be here amidst the August gathering. In fact, it all started 2 months back when a matter came before the Division Bench of Madurai Bench of High Court. The bench was headed by Honorable Dr. Justice Anita Sumant along with Justice R. Vijay Kumar. In the course of argument, Justice Anita Sumant was pleased to pinpoint a judgment of Karnataka High Court by a single judge, Justice Suraj Vijay Kumar. He has ventured into a new, what is called a scheme in Tamil Nadu, in Karnataka, for the purpose of integrating all the records pertaining to motor accident claims tribunals, ranging from the very first information report and commencing from the lodging of the FIR and from collecting documents from the hospitals and ending with the tribunals. There was a suggestion and slew of directions by Justice Suraj Vijay Kumar of Karnataka High Court. And the judgment has given us a small tip of going for a similar order in Tamil Nadu also. So the judge was pleased to dealing the matter on merits and to have this matter on record to explore further as to the proposed scheme of integrating all the documents pertaining to motor accident claims. So I requested the bench to appoint Mr. Vijay Raghavan, advocate, as the amicus curiae, and the bench was pleased to implicate more parties ranging from police department to transport department, health department, and finally up to the registry to gather information about how to implement the scheme in Tamil Nadu also. Then we slowly, the bench went into the details of the judgment of the Delhi High Court in Rajesh Chahi's case. Thereafter, the judgment issued by the Supreme Court with directions, the DAR, and finally the matter zeroed in into the Gohar Mohammed's case. So the matter is still pending. The matter is placed before the Honorable CJ for continuing the bench because Honorable Dr. Anita Sumant has now shifted to, I think, is in Chennai, principal seat. Now the matter stands in that stage, and all the stakeholders who were before the bench at the time were asked upon to give their suggestions as to how best to implement the scheme in Tamil Nadu. The very important point put forth by the bench was that the practice should be uniform throughout the country. In the matter of either DAR or the EDAR now before the Supreme Court, there cannot be different procedure for different states. The procedure to be followed should be uniform in all the states. In fact, the case before the amendment came into force, the Supreme Court was of the firm view that all the states should have a uniform procedure regarding DAR is concerned. So now let me confine myself to the changes brought into by the amendment to the Motor Vehicles Act before going into the Gohar Mohammed's case and the directions issued by the Supreme Court, because only when the amendment is properly understood or viewed, we can understand what is the extent of the suggestions and directions given by the Supreme Court to various stakeholders, including the state legal service authorities and the Tamil Nadu State Judicial Academy. Now, before going to the Gohar Mohammed case, I may just pinpoint the important changes brought into the Motor Vehicles Act in the year 2022. First substantial change that was introduced is in section 149. Under the amended section 149, a new claim settlement procedure is introduced. The claim settlement procedure under section 149 as amended from 1/4/2022 is as follows. On receipt of information of an accident, the insurance company should designate an officer. They call us as a nodal officer. So on receipt of the information of an accident, the insurance company is to designate an officer for the purpose of settlement of the claims relating to the accident. The designated officer by the insurance company has to make an offer within 30 days. The offer is in terms of settlement of the claim before the tribunal. If the claimants accept the offer, well and good, the tribunal shall pass an award and the insurance company is given a time of 30 days to deposit the award. If the claimant is unwilling to accept the offer, if they reject the offer, the hearing shall go on by the tribunal as we have been doing hereafter. So the first change brought into legislatively by the Parliament is to prescribe a settlement procedure under section 149. I repeat once again, on receipt of an information of an accident, the insurance company has to designate an officer. The purpose of designation is to settle the claims. That means when there is no dispute as to liability, etc. The designated officer has to make an offer regarding settlement within 30 days to this tribunal's concern. The proposal will be placed before the tribunal to the claimants. And if the claimants are in a position to accept the offer, the insurance company has to satisfy the award and within 30 days. In the event of disinclination by the claimants, they refuse to accept the award, then the matter shall be heard by the insurance, tribunal as an MCOP as we are doing now. This is the first legislative change introduced by the MESCT and the MCOPs by the MB Act 1988, introduced and amended in 2022. Then very important change in another provision of law is section 159 of the Motor Vehicles Act. Here comes the role of the police officers. Section 149 speaks the proactive role to be played by the insurance company and the tribunals. Section 159 speaks of the role of the police officers. Section 159 is a substituted new provision by which the police officer, we call it as SHO, station house officer, is required to prepare an accident information report. The purpose of directing the station house officer to prepare an accident information report is to facilitate the settlement of the claim by the tribunal. The same has to be submitted to the tribunal or by any other agency to be notified later by the parliament. So as of now, in the absence of notification, the station house officer has got a duty cast upon him to file an accident information report to the tribunal concerned. The object behind the substitution of section 159 is to make the police officer responsible to collect all the documents pertaining to the claim petition and place before the tribunal. So I'll come to the judgment of Honorable Mr. Justice V. Lakshmi Narayanan in Madaravan's case that is very much pertinent to this following aspect. So section 159 puts the initial initiative on the part of the police officers. So the police officers are under an obligation statutorily under section 159 to collect, collate and integrate all documents and to place them before the tribunal. This is the legislative feature. I don't mean the directions in the Gohar Bhavan case. We'll come to it a little bit later. Then there is a change in hit and run cases under section 161 of the Motor Vehicles Act. Hitherto, before 2019 amendment, we had a solatium scheme for the victims of hit and run case. Now section 161 has introduced a special provision, thereby making the Government of India to frame a special scheme and to pay compensation to the victims of hit and run case, relieving the General Insurance Corporation from making the compensation. So the solatium scheme and the GIC will have no bearing regarding hit and run case. Hereafter, it is the duty of the central government. They have to frame a new scheme, create a fund and compensate the victims of hit and run accident. Then one more scheme introduced by the Government of India by amending the MV Act in the year 2022 is a very laudable initiative called Golden Hours Scheme. This is a scheme where for even giving treatment to the accident victim, yes, a special fund is being created. We may know that all the victims may not be able to spend huge money to go to hospitals of their choice and to take treatment for the injured persons. So for such persons, the scheme is framed, a golden hour scheme, in which a special fund will be created and the fund will be utilized to see that the accident victims are immediately treated in the best hospital of their own choice. And we have to go for a new section under section 164 of the Motor Vehicles Act. After the advent of the new act, 163A has been dispensed with and 140 has also been dispensed with. Now, in the place of section 163 and 140, we have got section 164. 164 is almost akin to the amended new schedule introduced in the place of second schedule with effect from 2018. So in the year 2018, the second schedule or the structural formula or multiplier formula was taken away from the statute and a new table has been prescribed by which the liability under section 163A is made limited liability, because the Supreme Court held in Sunil Kumar's case that liability under section 163A is on par with no fault liability. So as per the amended Motor Vehicles Act with effect from 1/4/2022, section 164 speaks of no fault liability and the fixed amount of compensation payable in the event of fatal accident is 5 lakhs and in case of permanent disability it is 2,50,000. And as usual, there is no burden of proof on the part of the claimants. It is a no fault liability. And a new fund is sought to be created under section 164B, what is called a Motor Vehicle Accident Fund. So these are only some significant changes introduced in the year 2022, which might be relevant when we go through the Gohar Muhammad's case in shortest possible time. Now, before going into the directions issued by the Supreme Court of India to various stakeholders, let me just brief as a summation, what is the sum and substance of the judgment of Supreme Court of India in Gohar Mohammed case? Let me just give the directions given by the Supreme Court with the time frame. The purpose of summation is to highlight the time frame so that no stakeholders ranging from the police officers to the hospital authorities to the health department to legal service authority and even the tribunals, they cannot just dilute the frame. The time frame makes the judgment of Gohar Mohammed very special, so that let us understand the directions in the view of the time frame given by the court. First and foremost, what I want to speak of, two provisions of the Motor Vehicles Act and the Motor Vehicle Rules as amended should be gone into in minutest details. Section 159 of the amended Motor Vehicles Act and Rule 150A, 150A, capital A of the Central Motor Vehicle Rules 1989. These two provisions in relation to Annexure 13 of the Motor Vehicles Act are to be, first of all, gone into before understanding the judgment of the Supreme Court in Gohar Mohammed case. Section 159 of the Motor Vehicles Act as amended in the year 2022, Rule 150 capital A of the Central Motor Vehicles Rules 1989 and Annexure 13. These three are to be understood before understanding the judgment of the Supreme Court of India in Gohar Mohammed case. The key procedures, or let me say the salient features, are the directions of the Supreme Court vis-a-vis the time frame are as follows. The first and foremost thing to be done immediately after the accident, number one, after the accident or immediately after receipt of the information of the road accident, the first duty is cast upon the police officers. So any police officers who are there, please try to understand that the initial initiative is resting on your shoulders. So immediately on receipt of information about the accident, the investigation officer of the concerned police station, jurisdictional police, shall visit, inspect, take photographs and videographs of the spot. This is the first direction issued by the Honorable Supreme Court of India. So immediately after receipt of information of a road accident, the IO concerned shall visit, inspect the spot of accident and take photographs and videographs of the spot. Prepare a site plan. Take photos of the injured at the hospital and examine the witness. This is a far-reaching first and foremost feature of the direction, because this is going to be the point that sets the procedure in motion. So unless this point of perspective is achieved, the directions of the Supreme Court may not have a cakewalk. So the first and foremost responsibility lies on the police officer. So for if any police officer here, I like to say in Tamil also, ஒரு விபத்து குறித்து தகவல் கிடைத்தவுடன் ஒரு காவல் அதிகாரி செய்ய வேண்டிய முதல் கடமை உடனடியாக சம்பவ இடத்துக்கு விரைந்து சென்று சம்பவ இடத்தை நேரில் பார்வையிட்டு அது குறித்து ஒரு வரைபடம் தயார் செய்து அதற்கு அடுத்து புகைப்படங்களையும் வீடியோ படத்தையும் எடுத்து அனுமதிக்கப்பட்டுள்ள மருத்துவமனையில் உள்ள சிகிச்சை பெறும் காயமடைந்தவரை பார்த்து அவருடைய புகைப்படத்தையும் எடுத்து அங்கிருக்கும் சாட்சிகளை விசாரித்து பதிவு செய்ய வேண்டியது அந்த காவல்துறையினுடைய முதல் கடமையாகும். This is the first and foremost initiative given by the Supreme Court in the judgment. Then more important time-bound direction comes second. The IO shall intimate the accident to the claims tribunal. I will say it's a jurisdictional claims tribunal within 48 hours of the accident. The first time frame comes here. The IO concerned shall intimate the accident to the claims tribunal concerned within 48 hours of the accident by what is called a first accident report. the Supreme Court introduced what is called FAR, First Accident Report. That first accident report can be seen in Form 1 in Rajesh Tyagi's case of the Delhi High Court. As you all know very well, Justice J.R. Mida took extensive pain in dealing with the matter, and his judgment is the forerunner that has been accepted by the Supreme Court in Gohar Ahmed case, and Delhi motor vehicle rules have been amended, and all the recommendations of Justice Mida have been incorporated, and he has prescribed more than 16 forms as an annexure to the Delhi State Motor Accident Claims Tribunal rules. So Form 1 is also incorporated by the Gohar Ahmed case. The Form 1 is what is called a First Accident Report. It has to be prepared by the Station House Officer or IO. It has to be submitted to the Claims Tribunal concerned within 48 hours, and the copy of the FAR should be made available to the insurance company as well as the State Legal Service Authority. So this is the most important feature in the sense that when you come to speak of Malaravan's case law by Justice Honorable Mr. Justice V. Lakshmi Narayanan, we will come to know the scope and importance of this FAR. So the first and second duties are on the police officer. The second duty is to prepare an FAR in the prescribed form called Form 1 and intimate the same to the Claims Tribunal concerned within 48 hours, and copy given to the insurer and also the victims. So the copies of the FAR should be given to 4 kind of persons. The first person is the Claims Tribunal. The second is the insurer. The third is the victim, or in case of fatal accident, the relative of the victims. And fourth is the State Legal Services Authority. This is the second direction given by the Supreme Court with the time frame of 48 hours. Next time frame is the again duty cast upon the police department. The IO is duty bound to furnish the description of the rights of the victims. This is given in Form 2 as a flow chart. If any of one is able to have access to Rajesh Tyagi's case that is reported in 2021, Volume 1 TNMAC, page 145, Delhi High Court. 2021, Volume 1 TNMAC, page 145, Delhi High Court, where you can find after the judgment nearly 25 pages of annexures in which the forms are given in minutest details. This Form 2 is in the form of a flow chart. So the next time frame is the description of rights of the victims, that is in Form 2 flow chart. It should be given by the IO to the victim or the LRs of the victim within 10 days of the accident. Again, I repeat in Tamil for those police officers, காவல்துறை அதிகாரிகள் விபத்து நடந்த 10 நாட்களுக்குள் இரண்டாவது பட்டியலில் உள்ள பட்டியல்படி விபத்தில் காயமடைந்த அல்லது இறந்து போனவர்களுடைய உறவினர்களுக்கு அவர்களுடைய உரிமைகளை எடுத்துச் சொல்லும் விதமாக ஒரு அறிக்கையை அவர்களுக்கு தாக்கல் செய்ய வேண்டும். அந்த அறிக்கை இரண்டாவது பட்டியலின்படி அமைந்திருக்க வேண்டும். So once again, I repeat, the IO is duty bound to furnish the description of the rights of the victim or victims in Form 2, which is in the form of a flow chart, to the victims or the elders of the victim within 10 days. So முதல் 3 கட்டளைகளும் police officer கானது. The station house officer அல்லது IO has got 3 important duties immediately on receipt of the intimation about the accident. First is immediately upon the receipt of the accident. Second is within 48 hours. And third is within 10 days. Then come the fourth important time-bound direction, which is given to the hospitals concerned. This arises in fatal accidents. The hospitals are given directions to issue the postmortem certificate within 15 days. So the Supreme Court has fixed a time frame of 15 days. This is in consonance with section 159 and rule 150A of the Central Motor Vehicles Act and Central Motor Vehicle Rules. Then comes again the duty of the police officer, what is called Form 3. Form 3 is with relating to the driving license and driver particulars. It is the duty of the IO once again. The time frame is 30 days. So Form 3, which could be seen in Annexure 13, speaks of duty of the IO to furnish Form 3, that is called a driver's form. It should be furnished by the IO to the driver of the vehicle, and the driver shall furnish the information to the IO within 30 days. Now the duty is cast upon the IO as well as the driver. The IO should call upon the driver and give a form to the driver, that is Form 3, that has got the details regarding driving license. The driver is duty bound to fill up the form and give the form to the IO. It should be done within 30 days of the date of action. Here I want to correspondingly refer the amendment introduced by the Parliament in the Criminal Procedure Code and IPC recently. Now the Parliament proposes to make it a punishable offence if the person who causes the accident does not inform the accident to the police. The punishment is 7 years. So if you are having any academic interest, please go through the new bill which is pending before the Parliament, where IPC says that if a person causes the accident and does not inform the police, he should be punished up for the fine and imprisonment for up to 7 years. So now the Form 3 is a driver license form. It shall be prepared by the IO after directing the driver to fill up the form, and the filled form should be corrected by the IO within 30 days from the date of the accident. Next form is called Form 4, is meant for the owners of the vehicle. So this form shall be given by the, again, station house officer or the IO to the owner of the vehicle. The owner is called upon to fill up the form and give it to the IO. Again, the time given is 30 days. So the first time given is 48 hours for the police to prepare the FAR, first accident report. The second time frame is given by 10 days by the IO to furnish the description of rights of the victims in Form 2. And third is the information and postmortem report by the police officer to the IO within 15 days. And again, fourth is the 30 days time given by the Parliament to the IO to give a particular form to the driver and owner, color the particulars, and submit a claim to the tribunal within 30 days from the date of accident. So the cumulative effect of these directions are in the nature of making the procedure hassle-free, not driving the claimants or the LRs of the claimants to run from pillar and post. Okay, even immediately after the accident, எல்லா victim ஆலையும் எல்லா police stationலையும் போய் documents வாங்குறதுங்கிறது, it is not that easy. Again, where an ambulance chasing advocate comes into scene means the situation is becoming worse and worse. So this direction, if it is properly followed, will almost alleviate all the issues faced by the claimants in filing a original petition. Next important legislative change is Form 5. Form 5 is called IAR, Interim Accident Report. The IO, after collecting all the information ranging from FAR to Form 4, is duty bound to use all the information that he derived in Form 1 to Form 4 and file Form 5, that is called Interim Accident Report, IAR. It should be filed before the claims tribunal concerned. The IO shall submit an interim accident report, IAR, before the claims tribunal in the form of Form 5, along with copies of the documents within 50 days, 50 days from the date of accident. And again, the Form 5 should contain the enclosures, that is the copies furnished by the owners and drivers and other hospital. These forms should be accompanied in Form 5. It should be given to the claims tribunal within 50 days, and the copy shall be furnished once again to the insurer, victims, state legal service authorities, and the General Insurance Corporation. Now, the Act makes it obligatory to give the interim accident report not only to the claims tribunal, not only to the victims or the claimant, injured claimant, not only to the SLA, but also to the General Insurance Corporation. Then, again, the duty is cast upon the IO to verify the information gathered under Form 3 and Form 4. And after the interim accident report, the very important form comes into question, Form 10, that is called the very famous DAR, Detailed Accident Report. It is called DAR regime by the Supreme Court, DAR. So after filing an IAR and after verification of the forms collected in Form 3 and Form 4, the IO shall file a verification report. That verification report is in Form 10. The Form 10 should be filed by the IO along with the DAR. So this Form 10 is in the nature of a verification report. The verification report contains authentication of the information collected by the SHO or the IO and files a report to the claims tribunal stating that after the information have been collected, I have verified the same and the documents are true and correct, and it shall be forming part of a DAR. So Form 10 is the verification report to be filed by the investigation officer after verifying Form 3 and 4, and Form 10 shall be accompanied along with the detailed accident report. Then we go to Form 6 once again. The IO is once again called upon to furnish Form 6. This form is meant for the victims of the road accident and his LRs in case of fatal accident. And all the relevant information with relating to the accident and required to file a claim petition shall be given to the victims or the LRs of the victims by the IO. The time frame is 60 days from the date of accident. So on the 60th day, that is the second month, the claimants shall have everything on their hand without even moving an inch from his home. Everything will be made available in his doorsteps by the IO. So this is the most important change brought by the Parliament in amending the Motor Vehicles Act. The next important question, that is a case in a Supreme Court called Farzana's case. What happens in case of victim happen to be a child victims? Here, the Parliament has filed two annexures called Form 6A and Form 6B. These Form 6A and B are relating to child victims or minor victims. In case of minor or child victim or children of victims available, the IO shall furnish Form 6A to the victims who shall furnish the information within 60 days. So the relatives of the child victim in case of child being victimized or in case of parent died and child remains uncared for, the IO shall give a form to the relatives of the child and fill up the form and submit to the court concerned, Form 6A, within 60 days. What is the role of Form 6A is the important thing to be understood. On receipt of Form 6A, the IO shall send a copy along with the DAR to the Child Welfare Committee within 30 days. Here also a time frame comes. On receipt of Form 6A, regarding the victims who are happen to be children or LRs who are happen to be children, the IO shall prepare Form 6A and furnish copy 6A along with DAR, and it shall be given to the Child Welfare Committee concerned within 30 days. The Child Welfare Committee is duty bound to ascertain as to whether the child is in the need of any care and protection as per the laws of the land. You know well, we have got child laws which protect the rights of the child. So MB Act should not amount to a legislation infringing the rights of the child. So the amendment made it obligatory that the IO shall prepare Form 6A and give it to the tribunal along with DAR and copy marked to the Child Welfare Committee within 30 days. And the Child Welfare Committee has to ascertain whether the child concerned is in need of any care and protection as per the child legislative laws concerned. Again, the IO has got one more duty. The IO is duty bound to forward Form 6 and 6A to the State Legal Services Authority along with the DAR. So Form 6 and 6A should accompany DAR. It shall be given to the claims tribunal. It shall be given to the insurer. It shall be given to the victims. It shall be given to the State Legal Service Authority, and it shall be given to the General Insurance Corporation. Each all should be done within 30 days from the date of receipt of the Form 6 and 7. Then comes the very important document that is to be furnished by the IO to the tribunal within 90 days from the date of accident. The maximum time limit given by the Act and rules to the IO concerned is 90 days. That is the DAR, Detailed Accident Report. So the information collected by the police department in collaboration with the hospital and Child Welfare Committee, after getting the details from the hospital, drivers and owners and CWC, he shall prepare a complete report called a Detailed Accident Report. It shall contain a prescribed form report and annexure. It shall be furnished to the claims tribunal within 90 days from the date of accident, along with the following documents. The copy of DAR shall be furnished to the claims tribunal, to the victim, to the owner, to the driver, to the insurance company, and to the State Legal Services Authority. Then, if the IO is not in a position to file the DAR within 90 days, there are chances in which the IO may not be able to collect all the information and he may not be able to file the report 90 days. The rules are a little bit relaxed and the IO can seek extension of time over and above 90 days only by the written permission order of the claims tribunal. So the claims tribunal, jurisdictional claims tribunal, has to be approached by the IO in case of any requirement of extension of time, and the time can be extended by the tribunal depending upon the requirement of the IO. So this is the procedure regarding collection of data from the information of the accident till DAR is filed. So I repeat once again, the time limit is 48 hours to prepare FAR, 10 days to prepare the Form 2 to the victims regarding their rights, 15 days to prepare post-mortem certificate by the hospital, 30 days for the drivers to furnish particulars, 30 days again for the owners to give particulars, and 50 days from the date of accident for IO to file an interim accident report, and again 60 days for the IO to furnish the forms to the victims along with all the documents, and again 90 days for the IO to file DAR to the tribunal. In case of necessity, the tribunal can extend the time. This is the procedure regarding DAR to be filed before the claims tribunal. Then comes the role of our legal fraternity, role of the tribunal, the most important part of the story. If the liability is not in dispute, if the insurance company does not challenge the liability, the insurance company is duty bound to take a decision on the quantum payable to the claimants within 30 days from the date of accident. And such a settlement should be given to the tribunal in Form 11. So Form 11 is the form that is meant for the insurance company who are duty bound to honor the award on their own estimation in case of no dispute regarding liability. Then 30 days time is given to the claimant whether to accept the offer made by the insurance company or to reject. The 30 days is not only meant for rejecting, the 30 days can be used by the claimants to negotiate with the insurance company whether the amount can be enhanced further or not. So 30 days time is given by the Act for the claimants to negotiate and to decide finally whether to say yes or no to the proposal of the insurance company. If the offer made by the insurance company is accepted by the claimants, then the tribunal is now called upon to pass an award. The agreement or Form 11 by itself will not amount to an award. It is like an agreement given by the mediation. So based on the settlement proposal given by the insurance company, based on the acceptance given by the claimant, the tribunal shall pass an award and the insurance company has to deposit the award within 30 days. So total 6 months time, there is a chance for the court to pass an award and the 30 days time is given by the insurance company to satisfy the award. Just imagine the situation. If all these directions are scrupulously followed, believe me or not, on 90th day, the claim is closed, provided there is no dispute on liability. So all depends upon the primary duty the Supreme Court rests is on the IO. So it is for the police people to see that this amendment and the directions of the Supreme Court is brought into practice, let and spit. Here lies the judgment of Supreme Court in Goha Brahmat case. I'll come to it a little bit later. Then what happens if the claimants decline to accept the offer made by the insurance company? Then it is for the claimant to pursue the matter before the tribunal. The tribunal has to hear the matter as if it is an MCOP and the award shall be passed or the claim shall be disposed of within 9 months from the date of accident. So now the Motor Vehicles Act 2022 fixes a cap of maximum 9 months for the claims tribunal to dispose of the claim petition in the event of no settlement given by the claimants and the award shall be passed within 99 months from the date of accident. Then in the event of award being satisfied, the award shall be deposited within 30 days and it should be informed to the claimants within 15 days. In case the insurance company deposits the amount, it shall be done within 30 days and the court should intimate the claimants about such settlement and deposit within 15 days. Now it has become the duty of the tribunals to inform the claimants that the award has been satisfied and the award has been deposited. So it is a duty of the claims tribunal now. Now, what happens if the judgment debtor, either the insurance company or the owner or transport corporation, who fails to satisfy the award? As we said, the claimants have refused to accept the award. The court is supposed to pass an award. An award is passed within 9 months. And what happens if the insurance company or any person who is the respondent, judgment debtor, does not satisfy the award within 90 days? Then the award is liable to be executed on the expiry of 90 days from the date of award under section 169(4) of the MV Act or section 174 of the MV Act. We know well in Tamil Nadu, we can execute the award of MESCT either by filing an EP or by filing an appropriate procedure under the Revenue Recovery Act. Both are permissible. So if an award is passed, again 90 days time is given to the insurance company to challenge the award, or in case of no challenge, no appeal is filed and no stay is granted, the award can be executed either under section 174 of the MB Act, 169 or 174 of the MB Act. And a very important point given by the Parliament, then once an award is passed, the IO concerned shall present the copy of the award before the criminal court where the case is pending within 7 days from the date of award. This is where there is a kind of explanation is required. The IO may not be in a position to have access to the copy of the award unless he is made a party. There is no occasion for the IO to become a party of the proceeding. So what is inferred is every claims tribunal is called upon or expected to furnish the copy of the judgment award, gratis copy to the IO. It is for the IO to furnish the copy to the criminal court where the offence is tried against the driver of the vehicle. The time given is 7 days. You may be surprised why it is given to IO, because the claims tribunal and the criminal court, magistrate court, need not be in the same place. The crime took place in some other state means the criminal case will be in some other state or some other place, whereas the tribunal may be the native place of the claimant. So the only person who is common to both the criminal case and the award may be the IO. So the duty is cast upon the IO to take the copy of the award and give the copy to the criminal court concerned. That is the one of the changes made by the. So now, in the light of this amendment, the Supreme Court came to know that there has been lack of response, there has been lack of coordination, and some states there has been no response at all. So the Supreme Court was totally unhappy and appointed lot of advocates as amicus curiae, and after a detailed inquiry, this Gohar Ahmed judgment came to be passed on 15th December 2022. See 2023 volume 4 SCC page 381 is the citation. 2023 volume 4 Supreme Court cases page 381. Gohar Mohammed versus Uttar Pradesh State Road Transport Corporation. Our director was pleased to speak of the judgment in these initial steps. Now the question is, why the Supreme Court was called upon to issue such a direction, slew of direction? That is because the amendment of the Motor Vehicles Act and the amendment of the Central Motor Vehicle Rules did not produce the desired result. Especially states like Tamil Nadu, where ambulance chasers are having a heavy peak practice, the DAR has become a total failure except in the state of Delhi. So the Supreme Court was seized of the matter while hearing with Gohar Mohammed case, where the dispute was revolving around non-availability of permit up to this stage of the Supreme Court. So the Supreme Court caught hold of the matter and a slew of directions came to be passed. So before going to the directions issued by the Supreme Court, let me just give a small summation of the directions issued by the Supreme Court under a broad-based categories. First direction they have issued was to the police people. You can find the directions in para number 21 of the judgment. The forms and time frame that I have mentioned shortly ago may not match the directions of the Supreme Court in Gohar Mohammed case. That is why I first mentioned about the salient features of the Act and the provisions of the Act. I come to Gohar Mohammed finally. Please understand that after Gohar Mohammed case, you need not bother about the legislative intent by going through section 159 and 149 and rules. This Gohar Mohammed case is the Bible for all the station house officers, all the claims tribunal, all the stakeholders, including Transport Ministry, including all the Information Technology Department and the Joint Director of Health Service and even the doctors concerned. Para 21 of the judgment speaks of directions to police authorities. The Supreme Court says DGP for each state is directed to instruct all the police stations in the state to comply with provisions of section 158(6) of the Motor Vehicles Act prior to amendment and submit accident information report in Form 54 accompanied with copies of first information report, site sketch, mahazar, photographs, insurance policy, etc. to the jurisdictional MACT and the insurance company within 30 days of registration of FIM. This never happened even up to the Guha Mohammed case. Next direction issued in the year 2009. What I mean is the direction issued by the Supreme Court in Jai Prakash case. Jai Prakash case of the Supreme Court was issued in the year 2010. Imagine for 12 years the judgment was not complied with by any of the state. 2010 volume 2 SEC page 607 is the judgment in Jai Prakash versus National Insurance Company, where under the old Motor Vehicles Act, by relying upon section 158(6) of the Motor Vehicles Act, the directions came to be passed. Direction was issued to the DGP of Police. Directions were issued to Motor Accident Claims Tribunals. In para 21, there are directions to the Claims Tribunal. There were suggestions to the insurance companies, the same paragraph. There were suggestions to the legislatures that in Parliament and the state legislations. None of them were carried out by the stakeholders. For 12 years, we turned our deaf ears to the directions issued by the Supreme Court in Jai Prakash case. And most of us were not even made aware of the directions issued by the Supreme Court. Thus infuriated the Supreme Court and thus gave birth to the judgment in Guha Mohammed case. Before going to Guha Mohammed case, I may request all of you to go through academically the judgment of Delhi High Court in Rajesh Tyagir's case, which I referred to a brief ago. Rajesh Tyagir's case is going to be an eye-opener. That is 2021 110 MAC page 145. One man has made the change possible. Justice J.R. Mida in Delhi High Court and Justice P.N. Prakash in Madras High Court. The tireless judgments of Justice P.N. Prakash is followed by Justice Mida in lot of cases while he was sitting in the Delhi High Court. And Supreme Court appointed Justice Mida as amicus curiae and our own Mr. Vijay Raghavan as amicus curiae in the case before the Supreme Court in Bajaj Ahmad case. And our former judge, Honorable Justice S. Nagamuthu, is also one of the amicus curiae in the Guha Mohammed case. The very important suggestions made by the Rajesh Tyagir's case are extracted in para 23 of the Guha Mohammed case. The directions given by the Delhi High Court to the Delhi government were fortunately followed by the Delhi High Court for the simple reason the state of Delhi has got only 9 tribunals and only 9 police stations. So for such a state where the power center is very closer, all the infrastructures are moderately available. Considering the size of the state and number of tribunals, number of police stations, it was easy for them to implement immediately. And fortunately, the Delhi government was pleased to amend the Delhi State Motor Accident Claims Tribunal rules by incorporating the directions given by the Delhi High Court. That was not the case in other states also. So the directions given by the Delhi High Court can be gone into in para 23 of the Guha Mohammed case. The Supreme Court once again went on discussing all these matters, and once again in 2020, the Supreme Court came across a judgment called M.R. Krishnamurthy versus New India Assurance. 2020, volume 15 SEC, page 493. M.R. Krishnamurthy versus New India Assurance Company Limited. Again, there was a proposal to modify the procedure called MCTAP, mooted by the Supreme Court for the claims tribunal in pan-India basis. That was also not followed by the states concerned for want of knowledge and publicity. So, since the direction issued by the Delhi High Court and Supreme Court in various cases were not strictly followed, the Supreme Court was necessitated to give a judgment in Goharagamad case by inviting all the stakeholders and directing the Judicial Academy in all the states to take the initiative to see that all people concerned are sensitized. This is the initiative taken by our TNSDC is highly laudable in the sense that probably Tamil Nadu is one of the forerunner in sensitizing all the stakeholders. Sensitizing only the tribunals and advocate is not going to help unless the police officers are educated. I could see some police officers in the audience. காவல்துறையோட ஒத்துழைப்பு இல்லாம இந்த ஜட்ஜ்மெண்ட்டுடைய ஒரு டிரெக்ஷனோட நம்ம ஃபாலோ பண்ண முடியும். இன்ஃபேக்ட் அந்த விக்டிமுக்கு வந்து முதல் ஹெல்ப் பண்ணக்கூடியவங்க போலீஸ் டிபார்ட்மெண்ட் தான். ஸோ தி கொஹாரகமட் கேஸ் இஸ் மோர் ஃபார் தி போலீஸ் அஃபிஷியல். தி செகண்ட் ரோல் இஸ் ஒன்லி given for the SLA and DSLA, and finally the tribunals are supposed to play a proactive role. Then let me now come to the judgment of the Supreme Court in Goha Mohammed case straight and deal with the judgment. Before giving the directions, in one paragraph, the Supreme Court summarizes the plight of the claimants and the procedure to be followed. It can be found in paragraph 35, 36, 37, 38, and 39. These four paragraphs are going to give you an insight of what is the judgment of the Supreme Court is all about. 35வது பேரா, 36வது பேரா, 37வது பேரா, 38வது பேரா. 37வது paragraph is for the police officials. Very importantly, I just only read para 37 for your benefit. As per the rules, in the event of a road accident, the investigation must be started immediately on receipt of information by the police officer of the police station concerned. The investigation officer shall inspect the site of accident, take photographs, videos of scene and vehicle involved, videos of the vehicle involved, followed by preparation of the site plan, observation measure, drawn to scale. The Supreme Court says the site plan should be drawn to scale. அதுல 1 சென்டிமீட்டர்னா பூமியில 1 கிலோமீட்டர் அளவுக்கு it should be drawn to scale. Police officers here, please take note that the site plan should be drawn to scale. The site plan should be drawn to scale to indicate the width of the road as the case may be. ரோடோடைய அகலங்கள் கூட நீங்க ஸ்கேல் சைஸ்ல அடி சைஸ்ல நீங்க சொல்லி ஆகணும். Width of the road as the case may be and other relevant factors including the persons and vehicles involved in the accident. In case of injury, the investigation officer shall take photographs of the injured. யாருக்கு அடிபட்டு இருந்துச்சுன்னா அந்த இன்ஜூர்டு அடிபட்டனுடைய போட்டோ கேட்குறாங்க. The injury, in case of injury, the IO shall take photographs of the injured in the hospital, not on the site. ஹாஸ்பிட்டல்ல போய் அந்த இன்ஜூரியோட போட்டோ எடுக்கணும். In the hospital and shall conduct a spot enquiry examining the eyewitness and bystanders. அந்த இடத்துல இருக்கக்கூடிய அந்த விபத்தை நேர்ல பார்த்தவர்களையும் அந்த இடத்துல நிக்கிறவங்களையும் நடந்து ஒரு விசாரணை பண்ண சொல்றாங்க, preliminary examination. The intimation regarding the accident is required to be furnished by the IO within 48 hours to the claims tribunal in the shape of a FAR. I சொன்னேன் இல்லையா, first accident report, that is form 1. It is further required to be sent to the nodal officer of the insurance company. And the FAR insurance company designated officer, nodal officer அனுப்பணும். And having particulars of the insurance policy. அந்த காப்பியை அனுப்பி அந்த இன்சூரன்ஸ் கம்பெனில இருந்து அந்த இன்சூரன்ஸ் பாலிசியை அந்த ஐஓ வாங்கி டிஏரோட அட்டாச் பண்ணி ட்ரிபியூனலுக்கு கொடுக்கணும். On receipt, it is further required to be sent to the nodal officer of the insurance company on having particulars of the insurance policy. The injured or victims of the LRs of the victim, it shall be given to the victims, LRs of the victim, state legal service authority and insurer. They should be given the form by the police. So நான் திருப்பி போலீஸ்க்காக சொல்றேன், ஆக்சிடென்ட் பத்தி தகவல் வந்த உடனே ஸ்பாட்டுக்கு போயிட்டு ஸ்பாட்டை நேரடியாக பார்த்து ஒரு சைட் பிளான் ப்ரிப்பேர் பண்ணி அந்த சைட் பிளானை ஸ்கேலுக்கு, அதாவது நீள அகலங்கள் பொருந்தக்கூடிய அளவுக்கு ரோடுடைய அகலத்தெல்லாம் சொல்லி சைட் பிளான் ப்ரிப்பேர் பண்ணி அதை வீடியோ எடுத்து ஃபோட்டோ எடுத்து இம்மிடியேட்டாக அங்கே உள்ள பைஸ்டாண்டரையும் அங்கே நிற்கிறவங்களையும் ஐ விட்னஸை விசாரிச்சு இன்வெஸ்டிகேட் பண்ணிட்டு காயம்பட்ட நபரை போலீஸ் ஸ்டேஷன்ல இருந்து ஒரு ஆள் அனுப்பி காயம்பட்ட நபரை மருத்துவமனையில் வச்சு போட்டோ எடுத்து வீடியோ எடுத்து அந்த ரிப்போர்ட்ஸ் எல்லாமே நீங்க உடனடியாக நீங்க அந்த லீகல் சர்வீஸ் அத்தாரிட்டிக்கு இன்டிமேட் பண்ணணும். அது மட்டும் இல்லை, இன்சூரன்ஸ் கம்பெனி அந்த ஃபார்மை கொடுத்து அவர் வந்து பாலிசி காப்பியை வாங்கி அந்த காப்பியெல்லாம் சேர்த்து ஃபர்ஸ்ட் ஆக்சிடென்ட் ரிப்போர்ட் ரெடி பண்ணி அந்த காப்பியை எல்லா ஸ்டேக் ஹோல்டருக்கும், அதாவது ட்ரிபியூனல்ஸ், லீகல் சர்வீஸ் அத்தாரிட்டி, இன்சூரன்ஸ் அண்ட் விக்டிம்ஸ், இத்தனை பேருக்கு நீங்கள் காப்பி ஃபர்னிஷ் பண்ணணும். இந்த கடமையில் ஒரு துளி பாக்கி இருந்தாலும் அடுத்து வர்ற எந்த ஸ்டேஜ்லையும் ப்ராக்ரஸ் இருக்காது. The successful implementation of the scheme போலீஸ் ஆஃபீஸர் கையில் தான் இருக்கு. சுப்ரீம் கோர்ட்ல கிட்டத்தட்ட 6 மாசம் 7 மாசம் செலவு பண்ணி மணிக்கணக்கான அட்வொகேட்ஸ் ஆர்குமெண்ட்டை கேட்டு ஒரு ஜட்ஜ்மெண்ட் சொல்லி ஒரு பெரிய ஒரு ப்ரோஆக்டிவ் ரோல் பிளே பண்றாங்க அப்படின்னா, அதை இம்ப்ளிமெண்ட் பண்ண முடியலை அப்படின்னா தி சிஸ்டம் ஆஸ் எ ஹோல் வில் ஃபெயில். இந்த சிஸ்டம் ஃபெயில் ஆச்சு அப்படின்னா அதுக்கு முதல் காரணம் வந்து போலீஸ் ஆஃபீஸர் தன்னுடைய கடமையை செய்ய மறந்தால்தான் அந்த சிஸ்டம் ஃபெயில் ஆகும். I can assure to the police officer here on behalf of the legal fraternity, நீங்க இந்த உங்களுடைய கடமையை ஒழுங்கா பண்ணிட்டாலே எந்த விக்டிம்ஸுக்கும் எந்த இடத்துலையும் போய் யார்ட்டையும் நிற்க வேண்டிய சூழ்நிலை வராது. போலீஸ் ஆஃபீஸருடைய டியூட்டி ஒழுங்கா முடிஞ்சதுன்னா கிளைம்ஸ் ட்ரிபியூனலுக்கும் டிஸ்ட்ரிக்ட் அத்தாரிட்டிக்கும் ஒரு ப்ராப்ளம் இல்லாம அடிபட்டவங்களுக்கும் இறந்து போன வாரிசுகளுக்கும் ஒரு மிகப்பெரிய நன்மை பண்ணக்கூடிய ஒரு நல்ல ஒரு காரியத்தை பண்ணக்கூடிய புண்ணியம் உங்களுக்கு கிடைக்கும். So I humbly request the police officer to take serious note of this initiative and spread the message to fellows. உங்களுடைய ஐஏஎஸ் ஆஃபீஸர் ஒவ்வொருத்தரும் கோர்ட்ல வந்து ஒவ்வொரு சிட்டிங்லையும் நிற்கிறாங்க. போன தடவை I could see the commissioner of police of Madurai city in the Madurai bench. They all give assurance. பட் கிரவுண்ட் லெவல்ல பூமியில இறங்கி ஸ்பாட்ல போய் அதை நடைமுறைப்படுத்தக்கூடியவங்க உங்களை மாதிரி ஐஓ தான். ஸோ ஐஓஸ் எந்த அளவுக்கு கோஆப்ரேட் பண்றீங்களோ அந்த அளவுக்கு தான் இந்த சிஸ்டம் சக்சஸ்ஃபுல்லாக இம்ப்ளிமெண்ட் ஆகுங்கிறதால இட்ஸ் மை ஹம்பிள் ரிக்வெஸ்ட் டு தி போலீஸ் ஆஃபீஸர், எஸ்பெஷலி ஐஓ, டு கோஆப்ரேட் வித் தி ட்ரிபியூனல்ஸ் அண்ட் தி லீகல் சர்வீஸ் அத்தாரிட்டிஸ் அண்ட் தி ஸ்டேட் ஜுடிஷியல் அகாடமி. தென் அடுத்த போலீஸோட டியூட்டி வந்து ஐஏஆர், இன்ட்ரிம் ஆக்ஷன் ரிப்போர்ட். இந்த பேராகிராஃப் பேரா 39ல இருக்கு. ஸோ நான் வந்து I request the State Judicial Academy to furnish the copy of judgment to all the police officials. This will enable them to understand the problem easily. இந்த ரெண்டு பேராவும் படிச்சா அவங்களே நல்லா புரிஞ்சுக்கணும். Para 39 speaks of the interim action report. நீங்க அந்த பர்டிகுலர்ஸ்லாம் வாங்கின 50 நாள்ல ஃபார்ம் 5ல இந்த டீட்டெயில் எல்லாம் கொலேட் பண்ணி நீங்க வந்து போலீஸ் ஆஃபீஸர் வந்து கிரிமினல் கொடுக்கணும். உங்களுக்கு மிகப்பெரிய அட்வான்டேஜ் வந்து ஒரு போலீஸ் டிபார்ட்மெண்ட்ல என்ன ப்ராமிஸ் பண்ணியிருக்காங்கன்னா, பரிவாகன் அல்லது வாகன் அப்படிங்கிற கவர்மெண்ட் ஆஃப் இந்தியாவோட வெப்சைட்ல போய் நீங்க பர்டிகுலர்ஸ் வாங்குறதுக்கு உங்களுக்கு அக்சஸ் கொடுக்கறதுக்கு கவர்மெண்ட் ஆஃப் இந்தியா அக்செப்ட் பண்ணுங்க. என்ன பண்ணுவாங்கன்னா, உங்களுக்கு ஒரு ஓடிபி நம்பர் ஜென்ரேட் பண்ணுவாங்க. யூ கேன் ஜெனரேட் தி ஓடி நம்பர் அண்ட் கெட் தி பர்டிகுலர்ஸ். உங்களால சில பர்டிகுலர்ஸ் வாங்க முடியாட்ட டிஜிபி இஸ் கிவன் அஷூரன்ஸ் பை தி கவர்மெண்ட் ஆஃப் இந்தியா சர்ஃபேஸ் டிரான்ஸ்போர்ட் டிபார்ட்மெண்ட் டு ஹாவ் அக்சஸ் டு தி வாகன் அண்ட் பரிவாகன் வெப்சைட் அண்ட் போர்ட்டல். அந்த வெப்சைட் மூலமாகவும் நீங்க பர்டிகுலர்ஸ் வாங்கி கொடுக்கலாம். திஸ் இஸ் கிவன் இன் பேரா 39. அண்ட் குழந்தைங்க யாராவது இந்த விபத்தில் சம்மந்தப்பட்டிருந்தா ப்ளீஸ் கிவ் த ரிப்போர்ட் டு தி சைல்ட் வெல்ஃபேர் கமிட்டி. அந்த கமிட்டியோடைய ப்ரொடெக்ஷன் கேர் இல்லாம குழந்தையோடைய சேஃப்கார்ட் ரைட்ஸை சேஃப்கார்ட் பண்ண முடியாதுன்னு சுப்ரீம் கோர்ட் மிக தெளிவாக. தென் நீங்க ட்ரிபியூனல் உள்ள ஜுடிஷியல் ஆஃபீஸர்ஸ், ஐ ரிக்வெஸ்ட் யூ டு கைண்ட்லி கோ த்ரூ பேரா 45 of the judgment. உங்களுக்கான டைரக்ஷன்ஸ் பேரா 45ல வருது. எப்பன்னு கேட்டீங்கன்னா, இதுல இன்சூரன்ஸ் கம்பெனியோட ரோல் சொல்றதுக்கு முன்னாடி உங்களுக்கு ஒரு டைரக்ஷன் கொடுக்குறாங்க. இதுலயே இன்சூரன்ஸ் கம்பெனிக்கான டைரக்ஷனும் 45 செகண்ட் பேரால வரும். ஸோ பேரா 45 ப்ளீஸ் கோ த்ரூ, தட் இஸ் த டியூட்டி ஆஃப் தி கிளைம்ஸ் ட்ரிபியூனல். தென் உங்களுடைய ப்ரொசீஜர் டு பி ஃபாலோட் is given in para 49. application for compensation அது எப்படி நீங்க ப்ரொசீட் பண்ணுங்கிறது para 49ல வரும். தென் கடைசியில நம்ம பார்க்க வேண்டிய முக்கியமான பேராகிராஃப், திஸ் இஸ் வெரி இம்பார்ட்டன்ட் பேராகிராஃப்ஸ் ஃபார் தி ஜுடிஷியல் ஆஃபீஸர்ஸ், para 50, para 51 and para 52. இதெல்லாம் வந்து உங்களுக்கு ஒரு கைட்லைன்ஸ். ஐ டோன்ட் வாண்ட் டு வேஸ்ட் தி டைம் பை ரீடிங் ஈச் அண்ட் எவ்ரி வேர்ட் ஆஃப் தி பேராகிராஃப். இப்போ இந்த பேரா 50 படிச்ச பிறகு தென் the court proceeds to discuss all the reports one by one. Finally, the court takes into account the recommendation of the amicus curiae. ஒவ்வொரு amicus curiae யாருமே அங்க சாதாரண அட்வொகேட் இல்ல, அத்தனை பேரும் டெல்லி ஹைகோர்ட்லயும் சுப்ரீம் கோர்ட்லயும் உள்ள busiest practitioners. They spent their valuable time free of cost to help the victims. And after discussing the report, their recommendation and accepting the recommendation then and there are some directions given to the procedure, and I'll come to the collating paragraph of the directions of the Supreme Court. இதுதான் இனிமே நமக்கு பைபிள், குரான், கீதா எல்லாம் இதுதான். இந்த பேரா 78ல உள்ள டைரக்ஷன்ஸை தயவு செய்து நீங்க ஜெராக்ஸ் காப்பி எடுத்து நீங்க பக்கத்துல லேமினேட் பண்ணி நீங்க வைக்கவே வச்சுக்கலாம். பெட்டர். I would suggest the academy also to furnish the directions given in para 78 by giving a bullet point and to circulate each and every claims tribunal in the state. Ready reference தான். 78.1 விட்டுருங்க. 78.1ங்கிறது குஹார் முகமது கேஸை அவங்க சொன்ன ஜட்ஜ்மெண்ட். தி அப்பீல் வாஸ் ஃபைனலி டிஸ்மிஸ். நம்ம அதுக்கு போக வேண்டாம். 78.2ல இருந்து டைரக்ஷன் 78.16 வரைக்கும் வருது. அதில் ஜுடிஷியல் அகாடமியும் அதில் வரும். I'll go to 78.2 first. I'll read one by one, please. இது வந்து ஸ்டேக் ஹோல்டர்ஸ் தயவு செய்து மனசுக்குள்ள வச்சுக்கோங்க. These directions are going to be the future of the claims tribunal, future of the claims process, future of the MACT's effective disposal of the cases. Number 1, this is to the police officer. On receiving the intimation regarding road accident by use of a motor vehicle at public place, the station house officer concerned shall take steps as per section 159 ME. அப்போ போலீஸ் ஆஃபீஸருக்கு தெரிய வேண்டியது என்னன்னா, நீங்க மோட்டார் வெஹிக்கிள்ஸ் ஆக்ட்ல செக்ஷன் 159 நீங்க தரவா படிச்சு வச்சாதான் முடியும். தயவு செய்து உங்க அட்லீஸ்ட் அகாடமி ஹெல்ப்பையாவது கேளுங்க. I may request the academy to circulate section 159 to the police officers. ஏன்னா அவங்களுடைய கடமையை வந்து அந்த செக்ஷன்ல இருந்து நீங்க ஃபாலோ பண்ணீங்கன்னு சுப்ரீம் கோர்ட் சொன்ன பிறகு அவங்களுக்கு அதை சென்சிடைஸ் பண்ண வேண்டியது நம்மளோட டியூட்டி. ஸோ போலீஸ் ஆஃபீஸர்ஸ் ஹாவ் டு ஃபாலோ செக்ஷன் 159. Then the Supreme Court proceeds further. 78.3. After registering the FIR, the investigation officer shall take recourse as specified in the rules. அப்போ ரூல்ஸ் அவங்களுக்கு தெரிய வேண்டிய ஒரு தேவை வருது. ஸோ இன்னொரு ப்ரோக்ராம் நமக்கு பண்ண முடிஞ்சதுன்னா போலீஸ் ஆஃபீஸருக்கு நம்ம செக்ஷன் 159ஐயும் ரூல் 2000 ரூலையும் நம்ம சொல்ல வேண்டிய ஒரு கடமைக்கு வரும். ஐ திங்க் இட்ஸ் பீயிங் ஷேர்ட் இன் தி screen. I am thankful to the Judicial Academy. So 17.3 says, after registering FIR, the investigating officer shall take recourse as specified in MV Amendment Rules 2022 and submit FIR within 48 hours to the claims tribunal. 48 hours FIR நீங்க tribunal கொடுக்கணும். The IAR interim accident report and the DAR detailed accident report shall be filed before the tribunal within the time limit given by the court with the provisions of the act. Third, அடுத்தது, the registering officer is duty bound to verify the registration of the vehicle. இது வந்து RTOக்கு. யாராவது RTO இருந்தா please understand this point. The RTO department is duty bound to verify the registration of the vehicle, driving licenses, fitness of vehicle, permit and other ancillary issues, and submit the report in coordination to the police officer before the claims tribunal. So the registering officer and the reports எல்லாத்தையும் வாங்கி நீங்க police officer கொடுத்தா அவர் வந்து அந்த claims tribunal submit பண்ணுவார். This is in class 4. Then flow chart. The flow chart and other documents as specified in the rules shall either be in the vernacular language or in English language as the case may be, and shall be supplied to the as per the rules. The investigation officer shall inform the victims and legal representatives, drivers, owners, insurance companies, and other stakeholders with respect to action taken following the MV Amendment rules. அதுக்கு பிறகு இந்த எல்லா காப்பியும் கொடுத்த பிறகு இந்த ஃப்ளோ சார்ட் படி கொடுத்து ஒவ்வொரு ஸ்டேக் ஹோல்டருக்கும் நீங்க இன்ஃபார்ம் பண்ணணும். ஸ்டேக் ஹோல்டர் மீன்ஸ் இந்த அடிபட்டவங்கன்னா காயப்பட்டவங்க, இறந்து போயிருந்தா அவங்களுடைய வாரிசுகள், தென் டிரைவர், ஓனர், insurance company, and other stakeholders should be informed about the copies you have collected and furnished to the tribunals. Then again, distribution of police station வந்து இன்னொரு dispute. இந்த jurisdiction எங்க accident ஆச்சு இந்த dispute இருக்கிறதால this is a special direction by the Supreme Court in point 6. For the purpose to carry out the direction contained in 17.3, distribution of police station attached to the tribunal. ஒவ்வொரு ட்ரிபியூனலுக்குள்ள என்ன போலீஸ் ஸ்டேஷன் வருமோ அந்த லிஸ்ட் அவங்க ரெடி பண்ணணும். போலீஸ் டிபார்ட்மெண்ட்டோடைய கண்ட்ரோல் வேற, ஒவ்வொரு ட்ரிபியூனலுக்குள்ள என்ன போலீஸ் ஸ்டேஷன் வருங்கிற கண்ட்ரோல் வேற. ஸோ த சுப்ரீம் கோர்ட் வாண்ட்ஸ் எ லிஸ்ட் ஆஃப் போலீஸ் ஸ்டேஷன் attached to each and every claims tribunal. This should be given to the particular claims tribunal. எந்தெந்த போலீஸ் ஸ்டேஷன் எந்தெந்த ட்ரிபியூனல் வருங்கிற டீடைல்ஸ் அவங்க கொடுக்குறாங்க. தென் தி கோர்ட் ஸ்பீக்ஸ் ஆஃப் 7th பாயிண்ட்ல the duty of the investigation officer. The court says the role of the investigation officer is very, very important. He is required to comply with the provisions of the rules with the time limit as prescribed therein. Therefore, now the effective implementation of the MV Amendment Act and the rules framed thereunder, the specified trained police personnel are required to be deputed. இதுக்காக என்ன சொல்றாங்கன்னா Supreme Court requests the DGP to train police personnel and to depute them for such a work. This is direction given to the DGP of police. Direction பாருங்க. Therefore, we direct the Chief Secretary, DGP and each and every state union territory, they shall develop a specialized unit in each and every police station or at a town level and post the trained police personnel to ensure the compliance of the provisions of the MV Act. இந்த ப்ரொவிஷன்ஸ்ல ட்ரெயின் ஆன ஸ்பெஷல் போலீஸ் பீப்புளை ட்ரெயின் பண்ணி அவங்கள ஒவ்வொரு சிட்டி லெவல்லையும் இந்த ஜாப்ல இன்சார்ஜ்ல வைங்கன்னு சுப்ரீம் கோர்ட் கிளாஸ் 7ல டைரக்ஷன் கொடுத்துருக்காங்க. தென் எஃப்ஐஆர் போலீஸ் ஸ்டேஷன்ல இருந்து போன பிறகு தென் இதை ட்ரிபியூனல் என்ன பண்ணணும்? இங்க தான் உங்களுக்கு மலரவன் கேஸ் வரும். கிளாஸ் 8 ஸ்பீக்ஸ் on receiving FIR from the police station, the claims tribunal shall register such FIR as an miscellaneous application. Please, judges, please take note of this. Advocates, உங்களுக்கு எந்த கோஆபரேஷன் பண்ண போறது இல்ல. We should do it by ourselves. On receiving FIR from police station, the claims tribunal shall register such FIR as miscellaneous application. On filing the IAR and DAR by the investigation officer in connection with the FIR, it shall be attached with the some miscellaneous application, same miscellaneous application. The claims tribunal shall pass appropriate orders in the said application to carry out the purpose of section 149 of the MV Act, so on so. So ஒரு miscellaneous application நீங்க எடுத்த பிறகு ஒவ்வொரு தடவை ரிப்போர்ட் வரும்போதும் அந்த ரிப்போர்ட் என்க்ளோஷரை நீங்க அந்த miscellaneous applicationோட அட்டாச் பண்ணிட்டே வர சொல்றாங்க. Then the direction to the tribunal in clause 9. The claims tribunal are directed to satisfy themselves with the offer of the designated officer of the insurance company with an intent to award just and reasonable compensation. After recording such satisfaction, the settlement be recorded under section 142 of the MV Act, subject to the consent of the claimant. If the claimant is not ready to accept the same, the date shall be fixed for hearing and affording an opportunity to produce the document and other evidence seeking enhancement, the petition to be decided. In the event, the inquiry shall be limited only to the extent of the enhancement of the compensation, shifting the onus of the claimants. Very specific tribunal role define பண்ணியே கொடுத்தாங்க. So point number 9 is very much relevant for the tribunals to decide what is the scope of the inquiry before the tribunals concerned. Then GIC is requested to appoint nodal officer. ஒவ்வொரு இன்சூரன்ஸ் கம்பெனியும் ஒரு டெசிக்னேட்டட் ஆஃபீஸர் அப்பாயின்ட் பண்ணணும். அவங்களும் ட்ரிபியூனலும் போலீஸ் ஆஃபீஸரும் தே ஷுட் ஒர்க் இன் கொலாபரேஷன். தென் 11 தி மிஸ்செலேனியஸ் அப்ளிகேஷனுக்கும் இப்போ நீங்கள் வந்து அதுக்கப்புறம் கிளைமண்ட் வந்து ஒரு அட்வொகேட் வச்சு ஒரு கிளைம் பெட்டிஷன் கொடுத்தா நீங்கள் வாங்க மாட்டேன்னு சொல்ல வேண்டியது இல்லை. இந்த நீங்கள் ஏற்கனவே வாங்கின மிஸ்செலேனியஸ் அப்ளிகேஷனையும் இந்த கிளைம் பெட்டிஷனையும் வாங்கி அப்படியே நீங்கள் ட்ரிபியூனலுக்கு அனுப்ப வேண்டியதுதான். ஒருவேளை கிளைமண்ட் அன்சாட்டிஸ்ஃபைடாக இருந்தாங்க, அவங்க தனியாக ஓபி ஃபைல் பண்ணுறாங்க, அல்லது உங்களோட கம்பெனியோட ஆஃபருக்கு ஒத்து வரலன்னா அவங்க கிளைம் பெட்டிஷன் ஃபைல் பண்ணால் நீங்கள் ஏற்கனவே வச்சிருந்த மிஸ்செலேனியஸ் அப்ளிகேஷனையும் இந்த கிளைம் பெட்டிஷனையும் புட்டப் பண்ணி நீங்கள் கன்சர்ன் ட்ரிபியூனலுக்கு ஹியரிங்கு அனுப்பி வைக்கணும். திஸ் இஸ் தி டியூட்டி காஸ்ட் அப் ஆன் தி ட்ரிபியூனல். தென் வெவ்வேறு ஊரில் வெவ்வேறு கிளைம் பெட்டிஷன் ஃபைல் பண்ணால் இதுக்கு டிரான்ஸ்ஃபர் சிஎம்பி ஹைகோர்ட்டில் போடணுமா வேணாமா அப்படிங்கிறதுக்கும் Supreme Court specific direction கொடுத்திருக்காங்க. This is something new which goes against section 24 CPC. Special direction. In case of the claimants or legal representative of the deceased have filed a separate claim petition, the territorial jurisdiction of different high courts, அதை வந்து எந்த கோர்ட்ல முதல்ல கிளைம் பெட்டிஷன் ஃபைல் பண்ணாங்களோ அந்த கோர்ட்டுக்கு மற்ற பெட்டிஷனை டிரான்ஸ்ஃபர் பண்ணணும். திஸ் இஸ் a procedure given by the court. Then அதுக்கப்புறம் ஸ்டேட் லீகல் சர்வீஸ் அத்தாரிட்டியும் ஜுடிஷியல் அகாடமிக்குமான டைரக்ஷன் 14 கிளாஸ்ல இருக்கு. Then Registrar General of the High Courts, SLAs and the State Judicial Academy are what we are doing is same spoken, are requested to sensitize all the stakeholders as early as possible regarding the new act and new provisions. இது விஷயமா liability வரும்பொழுது எப்படி நடந்துக்கணுங்கிறதுக்கான கண்டிஷன்ஸ் எல்லாமே இந்த 78.2ல இருந்து 78.16 வரைக்கும் வருது. கடைசியா ஒரு 79 para, this duty is cast upon the registrar. Here I can request the academy to help the registrar because the last judgment of the para of judgment says the registry of this court, Supreme Court registry, is directed to circulate the copy of judgment to the registrars of all the high courts, chief secretary, and to make it to all the concerned person. நீங்க registry of the high courtum LSIயும் சேர்ந்து இந்த judgment காப்பியை எல்லா ஸ்டேக் ஹோல்டருக்கும் ஃபார்வர்ட் பண்ணோம் அப்படின்னா I think this might be an eye-opener and we can implement the directions in letter and spirit. With this, I end the first session. Let us continue after the team meeting with the permission of the director of the SGC.
Thank you, sir. We will now break for a tea and we will reassemble at 11:40.
Okay, so I will ready.
Thank you. Welcome back to this session. I hope you all have come back.
Sir.
Yes, welcome back to this session. And our reserve person will continue with this session. And after that, we will have an interactive session also. Thank you, sir.
Thank you, sir.
Thank you.
I think some of the stakeholders who are present are from other state also. So that's why I'm constrained to speak more on English than bilingual. With permission of the director. Yes, sir. Before I go further regarding the Gohar Muhammad's direction which we have discussed, I want all of you to go through one important judgment of our Madras High Court, rendered by Honorable Mr. Justice B. Lakshminarayan in a case between Malaravan versus Parveen Travels Private Limited. This case is basically on the application of Section 5 Limitation Act to claim petitions that are filed after 1/4/2022. We all know that in the year 1988, when Motor Vehicles Act was amended by replacing the old MV Act 1939, a period of limitation was incorporated by prescribing 6 months time to file a claim petition, and thereafter another 6 months time is given. That 6 months time can be condoned, but not after 1 year. So when the MV Act was amended in the year 1994, with effect from 14/11/1994, the Parliament thought fit of taking away the period of limitation as such. So the result was that a claim petition can be filed at any point of time. There was no limitation at all. When the Act was amended in 2022, an amendment came with a limitation cap of 6 months alone. No further period of extension of time was given by the MV Act. That means if any accident, and thank you for the judgment being shown, any accident that took place after 1/4/2022, a claim petition should be filed within 6 months. Section 166 was accordingly amended. There was no provision to condone the delay after the expiry of 6 months. That made a lot of people to suffer in a quandary, and one such case was filed with a delay of 8 days. The tribunal was left with no other option than to reject it. That man has come to the High Court, and that is a judgment before all of you on the screen. CRP against rejection of the petition. Here lies the very interesting point of law. And Justice V. Lakshminarayan was pleased to appoint again Mr. Vijayaravan as the amicus curiae. And I would say the judgment is one of the path-breaking judgment of the Madras High Court in the subject on hand. You may be raising your eyebrows. What is the relevance of judgment of the High Court dealing with Section 5 Limitation Act, its applicability to the Gohar Muhammad's case that we are dealing with now? Yes, there is a relevance. That's why I am emphasizing much on this judgment. I request all the stakeholders, all the presiding officers, all the insurance companies officers to just go through the judgment in its entirety. It's written very loosely by taking into account all the aspects in its amplitude. And since the judgment of Kerala High Court saying that Section 5 is applicable has been taken to Supreme Court and it is pending and kept in abeyance, this judgment does not speak of application of Section 5 and instead has beautifully traced the history of the claim petitions from the Act prior amendment and thereafter. If you are able to go through the judgment, I would like to take all of you to the judgment, especially starting from para 20. In fact, I want to say one thing more. When I was referring to the judgment of Gohar Mohammed, the text I was having was from the pages of the Supreme Court cases. The issue is that some law journals, they change their paragraph numbers. Some online journals, they also change the paragraph numbers. So the judgment that should have been circulated to all of you through Judice and Supreme Court website may have only 64 paragraphs. But whereas the journals, they split the paragraphs to suit their convenience. So I just want to say that the judgment I refer to as Gohar Mohammed should be related to SEC. The paragraph numbers I refer to was that of the SEC. And in case if you have any other judgment, you have to take pains in understanding which paragraph it corresponds to. Now, Malaravan's case is reported in 2023, Volume 2, Tamil Nadu Motor Accident Cases, TNMAC, page 416. 2023, Volume 2, TNMAC, page 416. I just take into account the page displayed before you, all of your good self in the screen. I just read para 20 for your understanding. Taking note of all these developments, this is Lakshmi Narayanan said, the Supreme Court rendered a judgment in Gohar Mohammed versus so and so. A reading of this judgment goes to show, I request the police officers to follow this very slowly, very carefully. A reading of this judgment goes to show that the police are no more playing a mere role of an investigating authority and stopping with mere parting of information. I repeat, a reading of this judgment goes to show that the police are no more playing a mere role of an investigating authority and stopping with mere parting of information. They are mandated by the Parliament. Underline the word the Parliament because of the section 159 and rule 154. They are mandated by the Parliament to file reports with the claim tribunal, which should treat the same as a claim petition. So the information furnished by the IO to the claim tribunal becomes a claim petition by itself. The claimants have been freed from the shackles and are no more burdened to search for the documents necessary for filing a claim. This is very important. The claimants have been freed from the shackles and are no more burdened to search for the document necessary for filing a claim. So, gone are the days when the hapless claimants or in the event of fatal accidents, the unfortunate victims of the road accident who already lost their beloved one, who are bereaved, who are made to run between pillar and post, from hospital to hospital, from police station to whatnot. Their plight is totally alleviated by the Madras High Court by stating that the effect of the judgment of the Supreme Court in Gohar Mohammed case, which is in the nature of implementing the mandate of the Parliament in the amended MV Act, that made the claimants free from the shackles of searching for documents and running from place to places. The court says the duty to report is now with the police. The duty to report is now with the police, and the duty to process the information given by the police and uploaded onto the website lies on the tribunal. When access is given to the tribunal to an FIR and the other details which have been uploaded by the police, the claimant need not be ready to run around or suffer from fear that his petition is barred by time. With this, I stop. Now, what is clear? Once the information is uploaded, once the tribunal is made accessible to the information, when it becomes a claim petition by itself, there is no requirement for the claimants to run after people or run after institution or documents. The court says, when access is given to the tribunal to an FIR and other details which have been uploaded by the police the claimant need not be made to run around or suffer from fear that his petition is time barred. It is the duty of the claims tribunal to access the information available to it and process the claim and to give succor to the victims. So this is the area in which Manaravan case speaks of Buhar Muhammad case, stating that even dehas or even without the claim petition formally filed by the claimant under section 166 of the Act, and information uploaded in the portals are furnished by the police as a FAR and DAR when they become by themselves a claim petition. To drive the claimant out of the doors of the tribunal, stating that you have come to me after 6 months is no more the situation. So the judge was pleased to hold that a claim petition filed after 6 months can be entertained because already information have been uploaded in the portal of the concerned people, and hence already a claim petition has been said to have been lodged. The law of filing the claim petition is set in motion, so there can be no limitation bar, the claim can be entertained. So I am not going to the question of limitation being extended. That's a separate matter for discussion. I hope the academy will take care of it. Now, I request all of you to go through the judgment for the reason that the judge has discussed the nuances of the change of law regarding the procedure to be followed in filing the claim petition. Here comes what is called DAR and EDAR. We already discussed what is DAR about and the judgment of the Supreme Court of India and Buhar Muhammad case and the efforts taken by the Parliament in amending the Motor Vehicles Act. And Madras High Court advocates have the highest advantage of getting orders after orders from the hands of the golden pen of Honorable Justice P.N. Prakash. The service he has rendered to the legal fraternity within the state of Tamil Nadu by writing judgments in Cholamandalam MS General Insurance Company versus Inspector of Police on 2 different dates is something I will say a layman service. I may refer to this judgment by citation 2017 volume 2 TNMESC page 773. 2017 volume 2 TNMAC page 773, Chola MS GIC versus IOP, Kadalur and others. This is the judgment of Madras High Court well before the Supreme Court delivered Buhar Muhammad case, and it speaks of DAR on the basis of judgment of Delhi High Court by Justice J.R. Midha. Again, another judgment 2017 2 TANMAC, same journal, page 792. The first judgment is dated 13/4/2017. The second is dated 12/9/2017. Same case law. In the first judgment I refer to in page 773, you may refer to page 780. In the seventh judgment I refer to, that is in page number 792, you may please refer to para 24. In these 2 judgments, Justice P.N. Prakash painstakingly directed the DGP and was successful in creating a DAR regime with the help of the information technology available in the police department. So the Madras High Court judgment was happily followed by Justice Midha while he was dealing with Rajesh Tyagi's case subsequently. In the year 2018, Rajesh Tyagi was of 2 judgments, 2018 one and 2021. 2018 ACJ page 1220. Rajesh Tyagi versus Jaibeer Singh was the first judgment. That is by Justice Midha, reported in 2018 ACJ page 1220. And the final concluding judgment of Justice Midha in Rajesh Tyagi in Jaibeer Singh is 2021 1 TANMAC page 145. I told in the morning. In the second judgment of Justice Midha in Delhi High Court, reported in 2021 1 TANMAC 145 Delhi High Court, Rajesh Tyagi, para page 198 is very much pertinent. I'm not here to read it verbatim. so that to waste the time of this gathering, I may request all of you to go through it to understand Gohar Muhammad in a better way. Now, what Gohar Muhammad is seen to achieve and what the judgment of Madras High Court pending before the division bench previously headed by Justice Anita Sumant and Justice Vijay Kumar is this: to integrate all the stakeholders and their portal. This is important in the meaning that unless and until we are able to integrate all the documents in one portal, I don't think we will be in a position to achieve the golden objectives of the DAR scheme and EDAR scheme by Gohar. I may request all of you to go through one judgment of the Karnataka High Court. I have only an online copy. I may request the Academy to circulate to it with the QR code. Justice Suraj Govindaraj of Karnataka High Court, Kalaburgai bench, reported in writ petition number 201961 of 2023. Writ petition number 201961 of 2023, within brackets MV motor vehicle, dated 21st July 2023. Divisional Manager, United India Insurance Company versus Ramu alias Ramesh and others. This judgment is unique in the sense that what is sought to be done by the Karnataka High Court is integration of all the documents from the stakeholders concerned. The relevant paragraph where the Karnataka High Court was pleased to issue a slew of directions is para number 25 of the judgment. I may request the Academy to circulate it with QR code to all of you. I just read some directions of the Karnataka High Court which may be pertinent, and the division bench of Madurai bench of Madras High Court is almost dealing with a similar exercise now. The first direction is, the judge says, I am of the considered opinion that necessary directions would also have to be issued to the DGP, Commissioner of Transport Department, Secretary Health Department, and also Secretary E-Governance. So the stakeholders in this matter are the Director General of Police, Commissioner of Transport Department, Secretary of Health Department, and Secretary of E-Governance Department. The first direction, all of them are required to implement the Central Motor Vehicle Amendment Rules 2022, single line directions. There should be no deviation in observing the rules of Central Motor Vehicle Amendment Rules, ipso facto, without any deviation. Second direction is very important. The State Police IT is directed to integrate the police IT system with the Integrated Road Accident Database / E-Detail Accident Report, EDAR. This is the new regime now. E-Detail Accident Report on the Parivahan website set up by the Ministry of Road Transport and Highways. So what is sought to be done by the Karnataka High Court? Probably Supreme Court may adopt it in its judgment, which is pending before the Supreme Court in Bajaj case, in which our beloved Vijay Raghavan sir is the amicus curiae. What is called EDAR? Before we achieve what is called EDAR, that is E-Detail Accident Report, electronic, there must be integration of all the documents by all the stakeholders concerned. So the direction is the State Police IT is directed to integrate the police IT system with Integrated Road Accident Database / E-Detail Accident Report, EDAR, on the Parivahan website set up by the Ministry of Road Transport and Highways by the Government of India. Next direction, the police IT is also directed to integrate with Unique Disability ID, UDID. The police IT is also directed to integrate with Unique Disability ID website set up by the Department of Empowerment of Persons with Disability of Ministry of Social Justice and Empowerment, Government of India, in order to track the disability caused to a victim of accident and the report issued by the medical board constituted under the Disability Act. So the disability ID given by the Department of Empowerment of Persons with Disability and the disability certificate issued by the medical board constituted under the Disability Act will be integrated with the police IT. Next, the police IT is to integrate with Forensic Laboratory Management System, FLMS, set up by under the state of Karnataka as also with the Vahan website. So the Forensic Laboratory Management System is also integrated with the police IT. Next, the police IT to integrate with all the insurance companies providing insurance service in the country so as to secure the details of the insurance policy in respect of the vehicles involved in the accident on the basis of the vehicle number. So all the insurance companies throughout the country are also integrated with the police IT portal. The police IT is to integrate with the transport department so as to secure the details of the vehicle, owner and the driver involved in the accident. All the above details to be made available to the courts by integrating with the case information system used by the court. All these information that are integrated with the police IT will be integrated with the CIS of the courts concerned. That will make the job of the claimants and the court very much easier. The Karnataka High Court did not stop with this. Irrespective of Rules 2022, in terms of Section 115 of the ME Act, if the investigation officer has submitted the FAR in terms of Section 159, the same would have reached the court for necessary action to be taken. It is on account of IO not having sent the FIR, the situation arises. So the court found fault with the IO initially. As I said, unless the IO sets the law in motion, the entire judgment of the Supreme Court and the entire exercise of the Parliament will be of no use. So on the basis of this integration of documents collected by the police IT from the central government department, it is not a difficult task at all for the SLA or DSLA or the police to collect data from the local authorities and to give a complete EDR to the tribunals concerned. So if this integration system of the Karnataka High Court is strictly followed in Tamil Nadu also, it is being contemplated by the Madras High Court and by the Supreme Court in future point of time, I am sure that no vehicle can be untraceable and no disability will be without knowledge, and by a click of a button, all the information can be gathered by the police and made available to the tribunal. Here lies the distinction between DAR and EDAR. DAR is nothing but an exercise by collecting the physical data, physical documents, and file it in form 1 to 13 as per the judgment of Supreme Court of India and as per the Motor Vehicle Act and rules and annexation. But when EDAR comes into question, everything is very easy. Like we are going to adopt e-filing very shortly. So all the documents from the website will come to the portal, and it is for the DGP to upload all the information, and there must be a common nodal agency or authority who will collect all the documents and upload in the prescribed form in the portal. So now EDAR is in the offing. Supreme Court is now working on EDAR. Supreme Court has already developed a module of artificial intelligence developed in a city called Lucknow, and our former judge of the High Court Madras, retired in Chandigarh, Justice K. Kannan, was instrumental in developing the module, and the module has been successfully tested. I am told that very shortly the module will be put into use. So these forms in the DIR now are manually to be filled up, and it has to be filed as a report before the tribunal by the police department. This is what is in force now after the amendment of the Motor Vehicles Act. If EDAR is implemented, this collation of all the documents will be done by electronic mode, and by a click of a button, it can be uploaded, it can be downloaded, and they will create an OTP, and you may be able to have access to the particular document. This is J.R. Midha is once again the forerunner of this EDAR system. He is the amicus curiae along with Mr. Vijay Raghavan before the Supreme Court. I am hopeful of a day shortly when Supreme Court is come forward with the EDAR, and I'm sure that the Parliament and the state legislature would amend the rules so as to make EDAR as part and parcel of the judicial process by which the claim petitions are processed and adjudged, making the hapless victim a happy one, because what is not easily done by a so-called old procedure is replaced by a more comprehensive, effective, practical solution. So I just want to conclude, leaving way for interactive session, stating that please go through section 159 and rule 154 and amended Tamil Nadu Motor Accident Claims Tribunal rule 45A. By the amendment of the Tamil Nadu MACT rules, what is sought to be done? I just read the notification. In exercise of the powers conferred under section 176, read with section 211 of the MV Act, the Governor of Tamil Nadu hereby makes the following amendment in the Motor Vehicle Tamil Nadu Motor Accident Claims Tribunal Rules 1989. Here, the Rule 4A has been subsequently inserted, thereby making some of the procedure and DIR compulsory. And I am sorry to say that not even a single claimant's advocate in Tamil Nadu has gone through the amendment. I could not see not even a single advocate in the insurance company, at least in Madurai bench, citing this to the tribunals and the High Court. So I may once again request our director to take special initiative to see that this amendment is brought to the knowledge of all the tribunals. Amendment of Rule 4A and the inclusion of Form 4 in Tamil Nadu Motor Accident Claims Tribunal Rules 1989. DAR is now statutorily incorporated in Tamil Nadu MACT rules. The form is given in the schedule, and we have got something new to be introduced to our judges and advocates. This abbreviation with it I will report. I'll just read 4A Rule 5 newly introduced. After Rule 4A, new Rule 45 is introduced. All the documents related to motor vehicle accidents, including the report in Form 4, that is DAR, shall be uploaded digitally or scanned or by any other means by the IO. Again, it is on the IO's shoulders. All the documents related to MV accident, including the report in Form 4, that is DAR, shall be uploaded digitally or scanned or by any other means by the IO on what is called CCTNS. CCTN means Crime and Criminal Tracking Network and Systems maintained by the Tamil Nadu Police Department. CCTNS, Crime and Criminal Tracking Network and Systems platform, and the same may be forwarded to the Claims Tribunal and Legal Services Authority digitally. Now Tamil Nadu has entered the EDAR regime successfully, officially, with effect from 19th July 2019. For 4 years, we have been ignorant of this EDAR scheme introduced in Tamil Nadu. I think only the Judicial Academy can take the initiative to reach all the stakeholders concerned. This rule further says it should be made forwarded to the LSA digitally. Upon such uploading of documents, SCRB, again the State Crime Research Bureau, shall duly intimate the report in Form 4 DAR digitally to the Claims Tribunal and Legal Service Authority concerned in the state. It further states all the stakeholders such as insurance companies, transport corporation, owners of the motor vehicles, drivers of the motor vehicles, Claims Tribunal, Legal Service Authorities, etc., can have access to the crime and criminal tracking networks and system. Now, what is made done? Because of successful implementation of EDAR, at least in Tamil Nadu, all the stakeholders are permitted to have access to CCTNS. Highest boon Tamil Nadu has ever achieved. Credit goes to Justice P. N. Prakash once again. He only made this possible. His direction made the government to pass this amendment. And it shall be, in view of the online crime and criminal tracking network system platform developed by SCRB and availability of necessary documents, so and so, the need for physical preparation of DAR is hereby dispensed with. In fact, I'm sorry to say that nobody in Tamil Nadu is aware of that. EDAR has been substituted in the place of DAR. DAR has been dispensed with in the state of Tamil Nadu on the advent of the amendment to Rule 4.5 of the TNMACT rules, and now EDAR is the rule of the state. So now anybody can approach the High Court. Anybody can approach the legal assistance authority. Anybody can approach the claims tribunal for access to CCTNS. So this amendment is revolutionary in this sense that EDAR has already come into play in Tamil Nadu. Who knows, the Supreme Court may be eager to receive this and to implement in its own order, because our Mr. Vijay Raghavan is there as an amicus curiae, and our Mr. Nagamuthu Justice is there as an amicus curiae, and our former Judge Justice Kannan is the E-committee member, and Tamil Nadu has got a very effective E-committee, and our own E-committee former member Justice Sivanganam is there in Calcutta. There is every chance for Tamil Nadu model being followed by Supreme Court for pan-Indian basis. But what is required is awareness and sensitization. So this EDAR is revolutionary in Tamil Nadu. That is why I made it as the last straw of the program. So let us be proud of the development going on in Tamil Nadu. Let us be proud of the scientific, what is called temperament we have. What we require is the cooperation of all the stakeholders and the determination of the persons concerned, especially the judicial officer, to see that EDAR is implemented. And though I'm an advocate, I may request all of you to ignore any protest by advocates concerned. Every initiative will have resistance. And we have to forget all these things. When typewriters were replaced by computers, there was a huge hue and cry. But now we cannot find typewriters anywhere. And we don't find any shorthand institute in any street corners. There are no typewriting institute. So any scientific invention will have initially, any initiative will have resistance. And it is for us to forge ahead. So I take this opportunity to request all the stakeholders from the IO to the director of the SJA to see that the letter and spirit of the amendment of Tamil Nadu MACT rules and the judgment of Supreme Court is implemented. And I thank for the opportunity for updating my knowledge by using this opportunity. Thank you very much, sir.
Thank you so much, sir. We will have an interaction section now. I request all brothers and sister judges of the district judiciary to raise any queries. If you have any doubts, you can make use of a resource person. He has touched extensively as well as intensively on the various provisions of the amended act, various forms that have been introduced in the newly amended rules, and also various judgments which have led to the final outcome of Gogam over the case by the Honorable Supreme Court. So I invite and request all brothers and sister judges to participate in the interaction.
Questions can be also posted in the chat box.
Judges can raise their questions even in the chat box available, and if possible. Otherwise, you can raise questions directly.
Sir, good afternoon, sir. This is Prakash.
Good afternoon, sir.
From Karloor district. So I just wanted to add two aspects.
Yes, sir.
One is related to EDAR system. I'm just happy to inform you that we are already following. A session was conducted in Tamil Nadu Judicial Academy, and
Yes, sir.
presiding officers for tribunal were trained, and SCRB has provided login ID and
Sir.
password individually to the tribunal to access the data uploaded by the SCRB.
Yes,
That
sir.
is the name. It is called EDAR. Subsequent to the
EDAR.
event of Justice P.N. Prakash. So we
Yes.
officers in Tamil Nadu, as rightly pointed out, we are the torch bearers. We already undergone training with regard to EDAR, and we are just implementing in most of the tribunals. And the newly open tribunals alone is yet to be received the user ID and password. One thing.
Yes.
And second thing, with regard to the role of police officers,
Yes, sir.
I would just invite your attention on the Rule 20
20.
of Central Motor Vehicles
Automatic rules.
Fifth Amendment Act,
Yes, sir.
Fifth Amendment Rules 2022, wherein there is a specific rule, rule number 20.
Yes,
Office
sir.
of Police shall be construed to be part of a State Police Act.
Yes, sir.
So the Parliament itself take a role, take a lead by incorporating these 2022 rules in the State Police Act. So if any violation has been noted by the tribunal or any other forum, we can invoke section 21,
21.
44 of Tamil Nadu District Police Act. It is an offence under the act.
Yes, sir.
So the Rule 20 path to the tribunals to put a tab on the police officials.
Very good, sir.
So I think we are having enough provisions and we are having enough systems, sir. The EDR is working. So I just wanted to add, sir, the state judiciary is already on toe. We are on toes.
Thank you, sir. Thank you very much. Because I'm happy to see that the progress is there. And I wish that the more EDR is seen day by day, because once EDR is successful, physical filing should not be find a place at all. Because if you go for physical filing, naturally this trouble will come. I'm happy to note that the Tamil Nadu is on the
Yes,
Yeah.
yes, definitely. That's
Thank
why I
you.
request your. I'm sorry to intervene in this
No,
aspect.
no, you are welcome. And I'm very happy to know that it is so nice of you. You are abreast of all the developments.
Thank you, sir. Kind of you.
Thank you very much.
Sir, this is from second additional district judge from Tiruvallur, sir.
Yes, sir.
Sir, I'm Murugeshan. I think, how are you, sir?
I'm fine, sir. I'm doing well. I'm doing well.
All right, sir. This is the only thing that we have received the MCOP cases and it is yet to be numbered. But as you said, no DAR has been followed. Subsequently, I just bring it to your notice that because of the metro work is going on, so we don't have any facility of the net connection, everything and all. So we don't have any DAR. It cannot be implemented. It cannot be uploaded. Second thing is that their DAR is, if it is accepted in a full spirit, the limitation has been saved as per the Magaraman case.
Yes, sir.
My question is that, see, once we have received all the documents, should we not put the claimants into the witness box and examine? Or if the insurance company directly comes for negotiation, that sir, we are ready to settle this amount, and what do you say? Then we are once again putting the claimants into the witness box if he is not acceding for the request made by the insurance company. Again, we are going back to the original proceeding, provided this is a summary trial.
No, that's why I say when there is a dispute regarding liability, we are going to the same old procedure. But if there is no dispute on liability, it is between the claimant and the insurance company and for the tribunal.
But
So,
will it be continuous to all the claimants, sir? Because the police cannot find sometime who are all the legal representatives, because no one can be suffered because the legal ads, there are 4 or 5 persons are there. Say they are collecting only particulars about 3. Even the claimant wants to get more. They are suppressing the particulars. And if they are sometimes after some time they come. No, my name has been left out by the police. And they have added me as a party. I lose the claim. in which how can we investigate into the matter provided only with the help of the DAR.
Yeah, in case if the information available, either DR or EDR is unsatisfactory or insufficient, we have no other option than to go for the conventional adversarial jurisprudence. There is no other option. For example, if any one of the claimants are opted out or left out or any liability is being disputed, you cannot just say that we will pass orders with the available records. Then the adversarial conventional, what is called adjudication process must continue. We are not going to replace. We are not here to replace the adversarial jurisdiction totally.
No, that is what I was saying, sir. Because 149, 166 is there. Because 149, 159, there is an introduction of 159. It clearly says that, sir says that in 149, as far as it's 159, this is amendment schedule to 2018.
18.
That is, yes, 19. That is 164 instead of 163A.
Yes,
Because
sir.
it has been introduced that the schedule has been formed. I think Justice Honorable Justice Vimala J has passed a judgment to
Yes.
implement this
Hit and run case.
second schedule. So sorry, this second schedule because of structural formula. That is perfect. But so far we have seen that somebody says that it has not been implemented. Somebody said it has been implemented. Still we are having a doubt that whether
Sir,
it is introduced or not.
the advent of 2022 Act,
Yes.
there is no second schedule at all. We have got section 164.
Yes.
So after 1/4/2022, we have no occasion to apply for the new accidents old act. So the question whether the procedure is retrospective or prospective is a different matter altogether. But for those accidents that took place after 1/4/2022, we are supposed to follow either 166 or 164. No question of following 163 or 140. So no more.
One more last question, sir.
Yes, sir.
As far as the injury cases are concerned, because we are sending them to the medical board,
Yes, sir.
but they are taking innumerable time to give the report, sir.
Yes, sir.
And the act government says that yes. See, one more correction. I think I may not be correct, but sir may be correct. See, there is no disability act. The disability act, I mean the appointment of the medical board is based
Yes.
not based on the disability act. It is only a GO passed in the year 2011. I think sir knows well. That is only for the purpose of has been issued only for the purpose of getting the disability for the physically disabled person to claim exemption in the income tax, to claim exemption in the train, to claim exemption in the flight. These are all things. Now it has been incorporated. But we are getting, that is what Mr. Vijay Rahman, when he had a discussion with us in the Judicial Academy, I raised the question some 7 years back. I think I raised this question when Sir come to National Judicial Academy. I think we had this question because they are not the doctors as far as the disability is concerned. They are not giving the particular which is appended in the Disability Act. What are all given in the that recommendation? Locomotor disability. They are not doing anything. Simply they are giving in one paper. This is the disability for which they have taken much time. So whether I think there is no answer for this in the amendment made by the Parliament. This is my concern.
My answer is very simple. Contemplating this situation,
Yes.
the Division Bench of Madras High Court in Prabhu's case,
Yes, sir.
subsequently led by Justice Vaidyanathan J and Rajiv Shakhtar,
Yes,
they
sir.
have modified the previous order. In
Yes,
case
sir.
of any doubt in the minds of the tribunal with relating to the disability assessed, there is no bar for the court either to call upon the medical board doctors to give evidence or to invite private doctors also. There is no bar. Recently, recently Justice C. Saravanan of Madras High Court. Just a minute. Just a minute. No, one minute. Recently, Justice C. Saravanan of Madras High Court has passed an order sitting in Madurai bench clarifying this position. You may search in the net where the petitioner has applied for constituting a medical board once again since the previous medical opinion was not satisfactory. But holding that such cannot be done, Justice Saravanan held that you can summon the doctor who had examined this, who had issued the certificate, the same certificate, and subjected to cross-examination, or you can also summon a private medical practitioner in the event of any doubt in the medical certificate issued by the medical board. So the Prabhu's case, Tata AG versus Prabhu by the division bench, answers your question. We are not bound only by the medical board opinion. We have got other procedures also. The summation paragraph of Prabhu's judgment will be in a position to clarify you, number one. Number two, the certificate issued by the medical board under the Disability Act is totally different from the assessment of disability for the purpose of getting compensation. So, marking a document will not be sufficient, means you can summon the doctor who had issued the certificate from the medical board. The judgment gives way for. Please go through Prabhu's case and decide.
One minute, because the GO has been issued by the central government says that if the medical board is not, the person, the claimant is not satisfied with the medical board, again he can appeal to the same medical board, because the assessment done by the medical board is not in conformity. Therefore, I am appealing before you. When the appeal,
You need not go to the GO at all. The judgment of the division bench is very clear.
one minute, because
You can go by Prabhu's.
available. Because
Sir, I think it just told you. The disability assessment is not for the purpose of assessment of disability for the compensation purpose. That is for a different purpose for getting employment or other things. If you have a doctor certificate, you follow Prabhu's case law, you summon the same doctor who issued the certificate, the same board, or else you can summon a private medical practitioner also. Prabhu's case is giving an answer for all these questions.
Subsequently, it has been modified by the Honorable Justice Vaidyanathan and Rajesh Satarji in the last paragraph.
This modification will answer all your questions.
Still, he is having a doubt whether we are afraid that the treating doctor should come or any other doctor should come.
Initially, it is medical board. Only in the event of doubt, treating doctors or private doctors.
All right, sir. Thank you, sir. Thank you.
I am Advocate Mohandas from Puducherry.
Sir,
At the outset, let me record my appreciation and hearty thanks for the Judicial Academy as well as respected resource persons. I have got 2-3 points to tell. First, addition regarding the medical board constitution. As good self has stated, it is not mandatory, but subsequently in Rajakumar versus Ajay Kumar case 2011, Supreme Court has said, like any other doctor can also be given. And as it is clearly stated, functional disability, physical disability are two different things. But now coming to the questions regarding this. On going through the Honorable Upper Court judgment in Boha Gomad case, I don't find anything regarding stipulation of time for medical legal report as well as the post-mortem report. On the other hand, it is only in the Central Motor Vehicle Rules amended.
rules only.
Yes, 15 days in Rule 16. But now when we are having a sensitization program for RTO officials, insurance officials, police officials, why not we have medical, the doctors who are supposed to issue that certificate within 15 days. I think it will be the fitness of things if they are also called for that. For that, regarding limitation, I on occasion go to the judgment cited by your good self, but the Goa government judgment refers to 166 only. 164 is a distinct one. For a moment, I may point out, it's a non-abstaining clause, not standing any kind of other law. And so, again, 165 says any claim for action arising out of intercourse, that says even 164. So, 166 alone is applicable in the Goa government case. So, limitation is applicable as far as 164 is concerned, because it contemplates any claim for compensation. Again, there is an adjustment, if I am very correct, is 3, where in respect of death or grievous had to due to an accident arising out of the use of motor vehicle, compensation has been paid under any other law for the time period can be adjusted. So it's a distinct one. Whereas the honor of the Upper Court judgment in Goa case refers to only 166. I think that it is not redundant. 166 4 regarding 6 months stipulation period is applicable for 162. It's my humble submission.
Yeah, the matter is before the Supreme Court. Even in Madras High Court, there are two different views. And Justice R. Vijay Kumar and Justice Saravanan has taken a divergent opposite views. Equally, Kerala High Court has given different judgment. So also Madhya Pradesh, the matter is pending before the Supreme Court. So for the time being, we cannot say anything about the limitation aspect. But the only thing is, let us not bother about limitation, because once DIR comes into court, it becomes an application. So the question of filing a physical application will not have much importance either under section 164 or 166, and irrespective of period of limitation, now any claims tribunal is entitled to receive application even after 6 months.
Further, this is regarding section 149, settlement by insurance company. There, subsection 1 says the insurance company shall, upon receiving the information of accident, either from claimant or through accident report, designate an officer to settle the claim relating to say. There is no time stipulation within which they should act. That's first point. Second, officer designated by the insurance company for processing the settlement of claim compensation may make an offer to the settlement before the claim tribunal, giving such within 30 days after following such procedure may be prescribed. I think the law is lacking. The procedure is not stated. For example, I am an advocate for the insurance company. Doesn't mean that I should act arbitrarily. Any insurance officer also, first of all, he is a human being, and then only is an officer. It is no doubt that just a compensation is an entitled right for every claimant. So in that case, the role played by the officer also should be objective one. So there should be some guidelines how he has to take, because disability is one thing, and also other factors are to be taken. So I think such a procedure prescribed by the government, I think that has to be done. The rule is not that. And last but not least, now DAR is treated as a application under section 115 police reports of them. And forms in several stages are given by the police to the legal authority. And now the law contemplates that once an application is, petitioner may file an application in different jurisdiction. 166 is the option of the claimant. And in one jurisdiction, the final report is filed. It is taken that. Now, I am in a situation where, like our union territory having 4 enclaves, Puducherry, Karaikal, Mahe, Enam. And what I feel is the application, once numbered by the tribunal, copy of information may be forwarded to UTPLSA. What I feel is that already they are having the district police as well as UTPLSA is having other details like furnished by the police. Now, if it's also there, easily that can be transferred. That will be of great help, because after passing an award, the tribunal is supposed to send a copy to the UTPLSA, and the investigation officer is forwarding reports. Now, what is required is, if the application is numbered by the tribunal, if copy is served on the UTLP also, the transfer other things will be easy. So our objective is to see that the government should reach the victim in proper manner. So in that, thank you very much for the giving opportunity.
You please collate all these things and write to your DSLA.
Yes.
And DSLA will send to the state authority.
Yes.
They will intend submit before the High Court concern. The bench is being constituted. I think they will take care of your application.
Yeah, I got some more doubts also. I will give you in writing.
So we'll write to the DLSA in due course. They will take care of it. Thank you.
Sir, this is Sri Kumar.
Yes, sir.
Good afternoon, sir. Sir, Appendix 13, Annexure 13, Rule 22 also clarifies on the point as to whether a DAR should be treated as a petition under 166 or under 164. So that gives much clarity to the question raised by the previous speaker.
Yes, sir. Yes, sir. You are right, sir. Right.
Yeah.
Right.
Sir, this is PDJ from Perambalur.
Yes, ma'am.
DGP has not so far constituted any police unit in this district, and so far no DAR or FAR has been filed into court. Only the petitioners are filing petitions, taking all the documents as before the amendment and coming to the close of the judgment. Only the DGP has to be directed by the High Court to form a unit, because the SP has no power to constitute any unit or police station to investigate into this particular ACT cases. The DGP has not done anything in this. I request that certain direction may be given to the DGP to constitute units in the police station or a separate police station in all the districts, so that this amendment can be implemented with the full effect and litigants will be more benefited.
Yes, ma'am. You are right, ma'am. That is why I told you in the beginning, the bench of Justice Anita Sumant and Justice Vijay Kumar is keen on integrating portal and appointing a nodal agency starting from the High Court till the DSLA level. So where the High Court contemplates kind of role by the district police office. So when DPO is proceed to service, I think a police officer up to the level of SP will be empowered to do all these things. Please wait for some more time. We are waiting for a good recommendation by the Madras High Court, and ultimately it will be implemented very shortly.
Thank you, sir.
Thank you.
Any doubts or questions from the panel lawyers or nodal officers, police officials?
Sir, one more question.
Please, you will be pleased.
Sir, Raman sir.
Yes, sir.
Again, there is invocation, sir. Sir, one more thing.
You are not audible clearly, sir.
Sir, so far they have filed applications here. The number,
Yes, sir.
this is the number, my court is a numbering court. No DIR has been filed. But how to save the limitations, sir, now? Because as per the Motherman case, immediately as soon as the DIR comes, the limitation starts. So there is no limitation. It's not bought by limitation as you say, because I have completely read the judgment. But
Yes.
because of the non-availability of DIR, the advocates are used to file the application as per the old model. Should it be numbered or not, sir?
So,
request, sir,
in the absence of DAR, whether a limitation can be condoned or not is the question. Am I right, sir?
Yes, yes.
So I have come across 4 or 5 occasions when
Yes.
DAR is available or the information is sent to police. Okay, when the police have not sent a single paper, what to do is the question. That is a matter to be discussed in length. In fact, my clients, 4 or 5 clients, I have suggested a writ petition before the High Court stating
Yes.
that the police have failed to file a copy. So it is obligatory. In that way, the High Court has to come to a rescue to saying that since the police have failed to file the application, the limitation has to be condoned. This is a point to be raised. That was not the point before the Madhavan's case. So a case is there, it is available, it is a debatable point. In the event of no DR or not even single FIR uploaded or given to the police or by the police, what is to be done is a question which is still a matter for debate. I think in suitable occasion we can discuss the matter. Our High Court will come to the rescue. But in my personal opinion, in view of the statutory requirement, there is nothing wrong in condoning the delay and taking the application on file.
Sir, until then, shall we take the number of applications, claim petitions? Until then, shall we number the claim petitions?
You are duty bound to take it because of the operative portion of judgment of Rashmar and Jai in Madhavan's case.
Okay,
Once
sir.
the law itself says that an FIR given to the police, to the IO, to the SLA can be a claim petition. This is only a supplementary procedure. This is not a primary procedure. So limitation will not come into operation is the point. You just go through the last para and come to a conclusion. In my opinion, you are not expected to return the claim petition as the bar will be.
Thank you very much, sir. Thank you very much.
In fact, it explains that the limitation is not. In fact, it limits that the registration of FIR, it should have been done within 6 months from the date of accident.
Even a complaint on the file of the police station, an FIR would amount an information to the police will become automatically a claim petition. That is the interpretation of the section 156 and judgment of Madras. In the event of no FIR filed within 6 months, it's a totally different situation. We have to deal with separately. There are very few cases where there is no FIR at all within 6 months. Madam, you are not audible, you are not clear, or I am not able to clearly hear you.
Good afternoon, sir.
Yes, ma'am.
Yes, Shanmugapriya principal subject from Europe, sir.
Yes, ma'am.
I'm having two queries. The first
Yes.
one is, you have stated that there is a time limit of 15 days from the date of accident for submitting the post-mortem report. This is with regard to the fatal accident cases. What about the injury cases?
This certificate of disability or wound certificate, the same case, you can substitute mutatis mutandis.
If it is so, whether the disability ascertained within 15 days of the accident.
No doctor will fix disability within 15 days. They'll only give you a discharge summary. You can say discharge summary or accident report or the wound certificate. Disability assessment is left to the concerned authorities in case of injury.
Then how the compensation can be settled at the initial point of time? By the tribunal.
That is for the insurance company open. They are at liberty to assess the disability as per the medical record and come forward with a solution. In case it is accepted of the claimant, well and good. Otherwise, it is for the court to decide the matter by following the routine procedure.
Okay, thank you, sir. My second query is, you have stated that within 30 days, Form 3 and Form 4 has to be submitted by the investigation officer. What about the fact in hit and run case?
It's a totally different matter. Now under the old act, in new act, we have got a new scheme and the government is supposed to frame a new rule. Now we are based on only on the claim under section 166 and 164. The hit and run is a totally different matter, and for which we are expecting a rules to be framed by the government of India. That is to be wait and seen. That is not going to be discussed in this DAR regime as of now. Probably the government of India may frame a rule by connecting DAR and EDR into hit and run case. As of now, that is not done.
And the third one is, you have stated that as regard to the Prabhu's case, the further holdings of Honorable High Court is coming into play only when the medical board certificate will not be accepted. Is it? Yes. I think is not so in the judgment.
No, you just see Rajkumar's case and Ajay Kumar's case also. You will have to file an application stating that the medical board certificate is not satisfactory. I may be permitted to examine a private doctor, and the courts are allowing it. That's why he told, please go through the judgment of Justice C. Saravanan given in Madurai bench recently, where it has been clarified by Justice Saravanan in minutest details.
Okay, thank you very much, sir.
And you will have to go to the evidence set regarding the binding nature of the doctors as an opinion, and report of the opinion is not binding. The court has got power to invite further evidence also, even on the basis of the opinion of the doctor. He is only an expert.
Thank you, sir.
Hello, sir. This is Hani from how are you?
Sir, good afternoon. Sir,
Yes, ma'am.
Good afternoon, sir. I am Member Secretary, Puducherry Legal Services Authority.
Yes, ma'am.
My doubt is, as per the amendment to the section 149, it says that a designated officer from the insurance, once he makes an offer, then it will be intimated to the claimant, and if the claimant accepts, the offer will be intimated to the tribunal. Yes, and if the claimant accepts the offer, then an award can be passed on consent, or otherwise it can adjudicate.
Yes, ma'am.
My doubt is, then the settlement process will be before the claims tribunal.
Yes.
Then why the copy or all the copies are sent to the Legal Services Authority? What is the role of the Legal Services Authority in this? Whether only to provide a panel counsel to aid them, or the settlement can be initiated by the Legal Services Authority, or only before the claims tribunal? Because it's made only to the tribunal.
No, actually, though the process of receiving claim petition is by the tribunal, the Act expects the DLSA to be a nodal agency like. Everything should be routed through the DLSA, so that in the event of any poor legal aid to be afforded, or in case of local law being referred, DLSA will have a say. So the copy to serve to the DLSA is to see that they are also aware of the procedure, they are keeping track of the matter. In case of poor litigant or in case of settlement, they will be coming to service.
So claim tribunal only has a jurisdiction to...
Final authority is only claim tribunal. In case of agreement, you may refer the matter forward. In case it is a disagreement, you may inquire into that.
Then my section 159 says that information, that accident information report shall be that is report to facilitate the settlement of claim in such form and manner within 3 months shall be before the claims tribunal and other agency as may be prescribed. What is that?
That is not notified. It may be the DLSA or SLA. We are waiting notification. As of now, the adjudication is only by the tribunal. No agency is notified. Why I say this, you may come across the latest Mediation Act. In the Mediation Act, there is a provision. There will be a provision for settlement of claims tribunal by the mediators. Hitherto, mediation was not extended to MACTs. Now, the Mediation Act 2023, notified on 14 September, has specific clause regarding settlement of dispute by mediators. So, a claim may be settled by the mediator without being referred to the claims tribunal. So the prescribed authority may be a mediator in the few courts.
Thank you, sir.
I think you understand the point. Mediation may be one of the adjudicating agency in the future.
I thought such other agency, whether the legal cells of the authority will fit into that.
Yes, Lok Adalat is an authority to pass an award.
The purpose of section 159 is to submit the accident information report to the tribunal within 3 months and for the purpose of settlement only. And in that case, such other agency is also included, whether the legal cells authority can play into that.
Yes, in case before the 90 days, it can be referred to Lok Adalat. That is only by a DSLA. If it is referred to mediation, it can be only by mediation. So such other agency may be in addition to tribunal, a mediation service provider or a mediation center attached to court or the DSLA by Lok Adalat.
No, I didn't get it, sir. Whether that there should be a direction or the legal cells authority can themselves can take that such other agency will be the legal cells authority.
DSLA can call for cases from the tribunal for settlement in Lok Adalat, or the DSLA may refer the matter to mediation under the new Mediation Act. It is not only the claims tribunal, there are other agencies also who can also adjust the matter in addition to claims tribunal.
So when a DAR report is received by a copy is received by the legal cells authority, based upon that, whether the legal cells authority can call for, can try to settle or
exactly, exactly, 100% you are right.
Sir, sorry for the interruption, sir.
Yes, ma'am.
Because it will be at the stage of pre-litigation. Yes. There is no case before the court. So, with regard to Lok Adalats, you cannot take it as a pre-litigation Adalat, and an award passed before an Adalat is a decree by itself. But what is contemplated is a settlement agreement. So, I think that mediation would be a proper forum and not the Lok Adalat.
Madam, just understand, once an agreement is reached, it may be the tribunal who passes the award. There is no impediment for the DSLA to intervene and pass an award.
So, meaning that pre-litigation award?
It's also contemplated because once an agreement is reached regarding the settlement by the insurance company and the claimant, there is no impediment for the legal authority to deal with the matter. That is the bar.
No, when the tribunal has been entrusted to pass an award.
That is why the words say, as other authorities that may be prescribed, if you go through Mediation Act, you will understand. Mediation Act has got a specific provision enabling MACTs to decide the matter through mediation.
And one more thing, sir. Since the initiate proceedings is from the insurance, when they will have to come with an offer. And that is the what is biggest hurdle here, because we are able to most of the insurance companies, in fact the panel lawyers expressed that they are disputing the liability because they don't want to take the first initiation, so that because they say that we are in lack of documents, especially certain things of legal hairs and other the policy and other all things. So what is the suggestion or advice you would like to give to the insurance companies, because it is at their initiation and offer has to come?
Now, I have been telling all the insurance people that EDAR, once it is implemented, it is a boon for the insurance companies. Whatever records they want will be made available. So once EDAR comes into operation, I think insurance company will better settle the claim. Otherwise, they will be losing interest.
Yes, sir. In the CCTNS portal, they are uploading the crime records, but not the actual forms as such, and especially about the driver details and the license, and because they are very particular about the policy violation. Like
that is where
license.
I said the Karnataka High Court judgment is very important. Integration of all the records, if it comes to Tamil Nadu also, once it becomes part of EDAR, all these documents can be very easily obtained from all the portals from Government of Tamil Nadu or Government of India. Then this EDAR will make all the solutions easily possible. I am hopeful that in maximum a year's time, it will be hassle-free.
Thank you very much, sir.
Let us hope for the best.
Sir, and apart from this,
Yes.
once negligence is disputed by the insurance company, their cost increases because local commissioner has to be appointed for examination of witnesses. So their cost is, so it would be better for them to raise the question of negligence only in appropriate cases.
See, in due course, we will come across all the situation, and in every beginning there will be a hiccups. We'll have to wait and see how it goes. Now we are in the entrance or the threshold. Let us just see for an experiment how it goes, then we'll decide.
Very true.
Sir,
Yes, sir.
this is Sunny Troll, an advocate from Nagarkoil.
Yes, sir.
How are you?
I'm fine, sir. Doing well.
Sir, my question is on two aspects.
Yes, sir.
Before I start, I would like to thank Tamil Nadu Police for keeping the profession alive for the advocates who are defending the insurance companies. And I would like to compare the Malaravan judgment, whether they have given a thought with respect to limitation and jurisdiction. When the DAR is going to be available, and you said the tribunals will have access to all the records. Now, you are aware that MCOP is a very lucrative business where the accident victims are immediately taken into the fold of the very prospective advocates from the petitioner side who are practicing from the other districts. They come to other districts and they frisk away the cases. Now, the question is, which tribunal is going to view that, and how the tribunal will value the limitation, and who will view the actual records, and which zonal office to which office will it be communicated, and how will you say that limitation has started from that point of time when the petitions are filed in different districts?
So that's what I told. Well, distribution of police station is one of the direction in Goha Mohammed case. The Supreme Court is very much conscious of a report of one of the amicus curiae who was very much curious about the distribution of police station. The DGP is given direction to distribute police station for each and every claims tribunal. For example, claims tribunal at Kallakurichi will have so and so police station. Claims tribunal at Vilupuram will have so and so police station. So they will decide the jurisdiction. You please go through Gohar Mohammed 78.1 to 78.14. You are answered, and in para 68, the report of the amicus curiae is more on the jurisdictional aspect.
Yes, so
because
that is
limitation, it is the date of accident that counts. It is
the
only
integrated criminal justice system, sir.
strictly safe.
ICJ.
Everything is made available. It will be made easy and understood once we start implementing in letter and spirit. All your doubts will be clarified once it is made possible. But I'm sure that unless EDAR comes into question, mere DAR will not be able to achieve this system. Only EDAR will be able to make this system successful. Let us wait. Let's wait.
Will the advocates appearing for insurance companies will have any role? Will we have any role after
without advocates for the company? There can be no adjudication. A nodal officer has to necessarily sit with the panel advocate in arriving at the award. Only the forum differs. So the nodal officer cannot directly sit with the judge and pass an order, and yes, necessarily seek the assistance of the insurance company lawyers. I don't think insurance company panel lawyers have any reason to worry.
Sir, good morning. This is Karthikeyan.
Sir, welcome, sir. How are you?
Good, sir. How are you?
I'm fine, sir. I'm doing well.
Sir, one small correction.
Yes, sir.
I think you said DGP has to issue instruction allotting the police stations and tribunals.
Yes, sir.
But this Gohar Mohammed judgment says it should be done by the RG.
RG. I'm sorry. I stand corrected.
Yes, sir.
It is RG. It is RG.
And
Thank you.
I found somebody from SCRB in our midst actually. If they can clarify whether they are sending this EDR to all the districts, because I understand that we are not getting. But somebody was saying, I think Mr. Prakash was saying they are getting EDR and they are processing it.
He was the only judge who was saying that he is getting everything from EDR.
So what is that? Whether they are getting for all the police stations or only for some police stations, and whether other districts are getting.
At least within Madurai bench jurisdiction, last occasion when the commissioner appeared, he said we are able to upload all the FIR, but linking the documents with other department, they have not done so far is a reply. I am not sure of within the jurisdiction of Madras High Court, I am not sure.
Thank you. Thank you.
Thank you, sir. Thank you very much. Again, this question is regarding jurisdictional issue. I told very issue, Motor Vehicles Act is very clear about jurisdiction, and there is no change of law regarding jurisdiction even after the amendment. So it is only the place of accident that counts, or the place of insurance company, or the place of the owner. DAR has nothing to do with the alter the jurisdiction of the courts. To request to fix a time limit to medical board is up to the High Court in the judgment, or we may expect the same from the judgment of Supreme Court in Bajaj Alliance case, which is still pending before the court. Bajaj case will be a comprehensive one regarding, it will be a furtherance of Gohar Mohammed case, and it will be a comprehensive judgment for all the aspects, including medical board, jurisdiction, limitation, and the direction under the Gohar Mohammed case. We'll have to wait for that judgment to come. Very shortly it will come, because Justice Kaul is on his heels, and before his retirement in November, we are expecting a judgment from the Supreme Court. Possible. I think insurance company in due course might come with a proposal. Right now I come to know that more settlements are being reported in high courts. Quantum cases are very less in number of being filed. In due course, I think insurance company will have more wisdom and come to the conclusion of suggesting amount and deposit the amount within time frame. It's possible, as in the case of land acquisition cases. It is possible, sir. It is possible. The issue is that insurance company has got its own level of amount of cap. For example, up to 10 lakhs, only the divisional manager can decide. After 10 lakhs, they have a regional office to decide. Such things are the only impediment for them. I think in due course, they will come with a specific proposal when nodal officers are being appointed. This question of fixing cap may not arise, and the company may be directed to deposit the amount. I'm hoping for a rule being framed under the golden hour scheme, in which also the company can be directed to pay the initial treatment cost. We have to wait for the scheme to be notified. So I'm aiming that it will be possible in due course. It's a very interesting question. I'm just waiting for the court fee to be paid on the FIR. Once a claim petition is taken on file at the FIR, I think collection of court fee may not be an issue, because court fee is payable only on a petitioner's claim petition under 166. FIR may not have any court fee. It will be totally free of cost. Again, once again, jurisdiction will not depend upon the FIR. It depends upon only the place of accident, or the owner's address, or the insurance company's address. There is no change of law regarding jurisdiction in the Act. So interest is governed by the judgment of Supreme Court. It says the interest is commensurable to the rate of interest given by the nationalized bank. So it is for you to make a plea before the court by proving the latest rate of interest. It is fluctuating. For some amount of investment, it is 7.5 lakhs. For senior citizen, it is 8 lakhs. For some amount, it is 6 lakhs. So percentage. For some person, it is 6%. For citizens of seniority, it is 8%. For amount above some amount, it is 7.5%. When the fixed rate of interest is not followed by banks, you cannot expect the court to fix the rate without knowing the available rate of interest. It is for you to prove from the bank concerned that for this claimant, this could be the rate of interest. But the judgment of Supreme Court says that the rate of interest will be the prevailing rate of interest given by the nationalized bank on the deposits. When it is not fixed, you cannot request the tribunal to give a fixed rate of interest.
Sir, Srinivas Raghavan, sir.
Yes, sir.
Sorry to interrupt.
Yes, sir.
As regards court fees, sir, Justice Asha J's judgment says that there is a proposal with the government to do away with the court fee itself, payment of court fee itself.
It's yet to be notified, sir. It is in only the proposal stage. Government of India is contemplating a procedure. As of now, if you go for a claim petition, you pay court fee. If you go for DAR-based, FIR-based claim petition, there is no court fee.
And even otherwise, once an award is passed and amount is deposited, you can deduct the court fees from that award.
If it is payable, it can be deducted.
Yes, so that issue of non-payment of court fee will not arise.
It is not going to alter the situation any further. It is always recoverable at the end of the story.
Yes.
Vehicle numbers are at times the name boards are damaged. At times the name boards are totally beyond visibility. So you can't expect the police always to be aware of the number. Anyhow, it's a good suggestion. I think we can recommend to the stakeholder called the police people. We'll try to inform them that if possible, let them also register the vehicle number and inform in the newspaper reports. Possible.
Unmute பண்ணுங்க.
Unmute பண்ணிடுங்க.
Thank you so much, sir, for answering all the queries raised by our brother and sister judges. And also we thank the judges also for participating very actively in this session. As insisted, we will also send a copy of this judgment to all district police office as well as the regional transport office, so that they will have a session by themselves and discuss with their officials. So they'll be getting more clarity on this subject even after discussion. So I invite my sister judge, Madam Additional Director, to give your vote of thanks.
Good afternoon, judges. Gratitude is the mother of all virtues. I place my sincere thanks to the Honorable High Court, Honorable Board of Governors for giving me this opportunity. I thank the Director, Tamil Nadu State Judicial Academy, for his welcome address. I thank the Honorable Judges of the High Court who had joined in the webinar sparing that time. I thank the resource person, Mr. S. Srinivasa Raghavan, for his excellent presentation on the Motor Vehicles Amendment Act, the Motor Vehicles Amendment Rules 2022, and the directions of the Apex Court in Gohar Mohammed versus Uttar Pradesh State Road Transport Corporation and another. Thank you, sir, for giving us the gist of the directions in the Gohar Mohammed to follow and implement the scheme for motor accident claims and giving us the background and the citations in respect of the subject. We would bullet the points in para 62 and share the same with the police officers and our judicial officers. Thank you, sir, for explaining EDAR and the integration of all the stakeholders. We had taken note of the request made by you, sir, with regard to the academy, taking the initiative for the implementation of the directions of the Apex Court. We would circulate all the judgments referred by you to all the stakeholders, including our judicial officers. Thank you, sir, for the wonderful session. To conclude, there can be no gainsaying that all these commendable directions must be earnestly implemented as directed by the Apex Court. The time limit given also must be adhered to as directed. The police and the insurance companies must also abide by what has been directed and act accordingly. No denying it. I thank the principal district judges who had taken all the initiatives and had extended their cooperation for the success of the present webinar. I thank the participant judicial officers for their active participation and the enthusiasm shown. I thank the insurance company panel lawyers, nodal officers of the insurance companies, regional transport authorities, the police officials who had also joined in the sensitization program through Cisco WebEx, as well as YouTube platform conducted in compliance with the direction of the Honorable Apex Court to effectively implement the directions contained in the case of Gohar Mohammed versus State of Uttar Pradesh Road Transport Corporation. Thank you, one and all.
Thank you. Thank you very much for the opportunity.
Thank you.